The Appellate Division First Department is now in session. Before the call of the calendar, I would like to welcome our virtual audience, the Next Generation Líderes Mentorship Program of Latino Justice Pearl Death. Welcome to the Appellate Division First Department virtual oral arguments. I'll begin the call of the calendar. People versus Timothy McKinney. Appellant McKinney gets 5 minutes of argument and 1 in rebuttal. The people get 5 minutes. Brian Meyer versus Legacy Yars. Appellant Legacy Yars gets 5 minutes and 1 in rebuttal. Brian Meyer receives 5 minutes. R. Sasha versus Marcus L. is submitted. Shilpa Saket, Appellant Saket gets 5 minutes and 1 in rebuttal. The respondents get 5 minutes. Green versus Reynolds Lane property. Let's see. Third-party plaintiff SDC gets 6 minutes and 2 in rebuttal. Cross-appellant Haddock gets 6 minutes and 1 in rebuttal. Respondent Green gets 5 minutes. People versus Lopez is submitted. All Terra America versus NFL and Discover Property versus the NFL are going to be argued together. Appellant receives 6 minutes and 2 in rebuttal. The NFL respondent gets 6 minutes. De Jorge versus Metropolitan Foods. Just give me 1 second. Okay, defendant appellant gets 5 minutes and 1 in rebuttal. Respondents, De Jorge gets 5 minutes and Jorge gets 5 minutes. King versus Marsh. King versus Marsh and McKellen Agency. The respondent has chosen to argue. I'll give the respondent 3 minutes. Appellant King is submitted. People versus Jason Vega. Appellant Vega gets 5 minutes and 2 in rebuttal. The people get 5 minutes. Nash versus Port Authority. Appellant Nash gets 5 minutes and 2 in rebuttal. Port Authority and respondent Locasio get 5 minutes each. Lopez versus the MTA. Appellant MTA gets 5 minutes and 2 in rebuttal. Lopez respondent gets 5 minutes. Suveran LLC versus Brainchild and Company. Appellant Brainchild gets 5 minutes and 2 in rebuttal. Cross appellant Suveran gets 5 minutes and 2 in rebuttal. Faustino versus New York City is submitted. Jane Doe versus Termill. Appellant Jane Doe gets 5 minutes and 2 in rebuttal. Termill gets 5 minutes. Black versus Franken Buildings is submitted. Green 333 Court versus R&L Life is submitted. The first case for argument is People versus McKinney. Let me first hear from Appellant McKinney.
All right. Good afternoon, Your Honors. May it please the court, Andrew Shepperly on behalf of the appellant, Timothy McKinney. The evidence for this case comes largely from video evidence. However, the video evidence is highly ambiguous with regard to McKinney's intent. Not only is it so ambiguous that it is legally insufficient, but the video shows ample evidence that the trial court erred when it refused to give pedant larceny as a lesser included offense. Looking at the wider context of this video, this was a randomly initiated altercation that was started by Perez-Diaz. If Perez-Diaz had never touched Jennings on the day of the incident, there is no indication that Jennings would have barred his way down the block.
So you think that that the video shows that you were not, the way you argue in your brief, that you were not involved with the altercation with Mr. Jennings, and you did not assault the victim here?
Well, Your Honor, I would say what we're arguing is that McKinney never had a conscious objective at the time force was used to forcibly take property. So from McKinney's view, he looked down the street and he saw someone he knew, Jennings, in a verbal altercation with someone he didn't know. McKinney inserts himself in this altercation, but really, from McKinney's view, he didn't have any indication that Jennings was going to rob Perez-Diaz.
The question is really the nature of his involvement, right? Was it minimal involvement or was it a significant one?
Well, to speak to that point, Your Honor, I think his involvement was very minimal, but also there just isn't enough evidence as to Mr. McKinney's intent to convict him of a second degree.
This is Judge Singh. Counselor, what about the fact that Mr. McKinney appears on the scene just shortly after the altercation, and significantly, he assists in removing the victim's belt? Wouldn't that sort of give a basis for the jury to infer that defendant and co-defendant Jennings both shared an intent to steal by force?
Well, Your Honor, yeah, I think it could give a basis for the jury to infer. But if we talk about the lesser included offense here, what the jury was not allowed to infer, or what the jury was not allowed to decide, was whether McKinney only committed larceny. The jury was given this impossible choice because they saw the video and they saw McKinney taking Perez-Diaz's property, and McKinney readily admits that he took property. But what the jury was not able to consider was whether he just committed larceny or whether he committed, was not able to consider whether he committed just larceny. The jury had to decide, looking at the video and seeing what they thought was a crime, they had either to decide that he committed second-degree robbery or that he was innocent. And the whole point on the second, the refusal to charge the lesser included offense, the jury should have been given the option to decide whether.
But what's the evidence? What's the evidence that that the defendant was acting, I guess, in your words, opportunistically only, just exploiting what was there? Because it appears, I mean, they know each other, and at least from what I laid out, doesn't the video suggest that they were acting together during the robbery?
So it is true, Your Honor, that they do know each other, but we have to remember, the day of the event, that there is no evidence that Jennings and McKinney spoke to each other before, during, or after this incident. And then thinking it again from McKinney's perspective, when he joined this, he only saw a verbal.
Why do they need to speak with each other if their conduct suggests that they were acting together? I mean, it's pretty clear that when the victim was punched and fell to the ground, the defendant in this case first moved his left hand towards the victim, right? He then made a fist with his right hand and cocked it back. So clearly this is not an innocent participant. He participated both in the conduct in which the co-defendant was involved in, right?
That's correct, Your Honor, that he injected himself into that altercation. But the point here is that McKinney did not possess the required intent at the time that the force was used to rob Perez-Diaz, to convict him of second-degree robbery.
Do you have an explanation to why he kicked the wallet a couple of feet away to his right once the victim was on the ground?
Well, Your Honor, after Perez-Diaz was already knocked out on the ground, this is when McKinney formed the intent to take property. So Perez-Diaz was already unconscious on the ground, and seeing this, McKinney decided, well, I will opportunistically now commit larceny. So him kicking the wallet away on the ground, that does fit into the petit larceny and his intent to opportunistically take property from Perez Diaz, who was unconscious.
Couldn't the same thing be said then of the co-defendant? Because the video shows that McKinney was holding the complainant while the co-defendant was also holding the complainant by the neck. So both of them are seen holding this complainant. Then, based on your argument, then they're both just guilty of larceny, as opposed to a robbery.
Your Honor, speaking to the second point, the lesser included offense, there is evidence that McKinney never used force against Perez Diaz. So the first is that Perez Diaz has no recollection of McKinney being there. And the second is that the prosecution at trial showed a still image of the video to a witness, or to a trial witness, and said, "Can you see McKinney restraining Perez Diaz?" And the witness said no. The prosecution asked one more time, and the witness confirmed he could not see McKinney touching Perez Diaz. So that right there are two pieces of evidence that cut against an argument that McKinney used force against Perez Diaz. So I think, especially to the second point, the petit larceny should have been charged as a lesser included offense, because when the evidence is viewed most favorably to the defendant, it is not true that every possible hypothesis except guilt of a higher crime was shown. McKinney was entitled to have petit larceny charged as a lesser included offense, and there is contested evidence as to whether McKinney used force during the incident.
Okay, thank you, Mr. Spurley. Let me hear from the people.
Good afternoon, Your Honors. Michael Yetter for the people. First of all, Your Honors, defendant's guilt of both counts of robbery, including his intent to forcibly steal from Perez Diaz, was proven beyond a reasonable doubt. I think the video really tells the tale here, especially if you start on the video, and what we pointed in our brief, around 43:34. Once Jennings grabs Mr. Perez Diaz by the neck and pushes him towards the door, the defendant jumps into action. He puts his arm up near Perez Diaz's chest area. He leans on him, and his foot is actually behind Perez Diaz's foot. And then while they're holding him there, Jennings is trying to reach into Perez Diaz's pockets. At one point, around 43:40, defendant looks down and sees this. And then he helps Jennings by pushing away the woman Raquel, who was actually trying to stop Jennings from engaging in a physical altercation. And then once Jennings punches Mr. Perez Diaz, as we've been discussing, the defendant himself cocks his arm back and looks like he's about to punch Perez Diaz, but he pulls the punch because it appears that Mr. Perez Diaz is at that point unconscious. Then, of course, he aids Mr. Jennings in removing the belt, and he kicks the wallet away and takes both those items with him before he leaves. We also think that there's no reasonable view of that evidence, viewing the video, in which the defendant had the intent to steal property from Mr. Perez Diaz, but lacked the intent to do so by force. One of the biggest distinctions that was borne out at trial and in the briefing is the attempt to compare the defendant to the woman who was inside the bakery the entire time. She was admittedly part of Jennings' group before the incident occurred, but during the entire physical interaction, she was inside of the bakery. And after the physical interaction, she comes out of the bakery and picks up an item, it might have been money or something, out of Perez Diaz's pocket while he's seemingly unconscious on the ground. That woman and defendant are not similarly situated. There is no reasonable view of that evidence in which that woman and defendant are both guilty of petit larceny. And so we think that just highlights the difference between
in fact,
those two here.
Is that the same woman that the defendant himself pushed away before he began participating in the encounter with the victim?
No, Your Honor, I believe that woman that you're referring to was Raquel, who was the one that defendant Jennings was speaking to.
Okay.
But this woman was actually inside of the bakery the entire time, but she had arrived sometime before the incident and was seemingly part of the group of people that Jennings was with that day. But really, there's just, I think if you review the video, I do want to point out The fact that Perez Diaz has no recollection of the defendant participating is not particularly relevant here. He said he was focused. He testified he was focused on Jennings the entire time. In fact, Jennings himself testified at trial and said that he was not aware that the defendant was there either, because he too was focused on Perez Diaz. And really the fact that the witness Batista could not, when he viewed the video at trial, see that the defendant had put his arm on Mr. Perez Diaz, really we don't think is relevant. The video evidence speaks for itself. And that was what the judge reviewed in determining whether or not to grant the lesser included offense charge. And that is, of course, what the jury viewed in the jury room. We think there's no merit to the defendant's remaining claims, and I'm happy to talk about them. But unless the court has any questions, we ask you to affirm.
I think we're good. Bench, I think we're good. Thank you, Mr. Yetter. You get 1 minute rebuttal.
Thank you, Your Honor. I would just to focus again on the lesser included offense. We've heard a lot of evidence from the prosecution's view, but the evidence must be viewed in the light most favorable to the defendant. And the fact is that until the moment, the seconds before Jennings was knocked out by Perez Diaz was knocked out by Jennings, McKinney had no way to know what Jennings was intending. Viewed from his perspective, he joined an altercation. He joined to help his friend. He had no way to know that his friend was going to commit robbery. It was unfortunate that he joined it, but it really was not until after Perez Diaz was on the ground that McKinney formed the intent to opportunistically commit petit larceny. And if there are no more questions, I will rest. Thank you.
Thank you. Thank you both. Breilmeyer versus Legacy Yards.
Appellant ready.
Do we have respondent Breilmeyer on the line?
I'm here, Your Honor.
Okay, so let me hear first from Appellant Legacy Yards.
Good afternoon, Your Honors, and may it please the court. My name is Brian McLaughlin of London Fisher, representing defendants appellants in this appeal. Your Honors, the trial court erred plaintiff's remaining labor law claims. Those claims are based entirely on an unsupported allegation that a hazardous scaffold caused plaintiff to fall. This allegation has been roundly refuted by numerous pre-litigation admissions in the form of documentary evidence, some of which are signed by plaintiff himself, all of which were confirmed by plaintiff as accurate at his deposition. These admissions established that no fall took place at all and that there was no scaffold defect. Rather, plaintiff merely felt—
Mr. McLaughlin,
yeah.
I concede that there are different versions or at least two different accounts that I can detect that were provided by plaintiff on how he was injured. You have the accident report and the C3 report, as well as the medical reports. They seem to suggest different ways that the accident took place. But isn't that precisely why there are triable issues in this case, and that someone should basically, a trial of fact should filter through that evidence or the inconsistencies that appear to be in the record?
Respectfully, no, Your Honor. These don't rise to the level of tribal issues of fact because all of these pre-litigation statements are consistent in not mentioning anything about a fall, not mentioning anything about a scaffold defect. All of them talk about—
Judge Singh, so essentially what you're saying is because the workers' comp chiropractic records don't mention the fall, that it's manifestly untrue, that the plaintiff's statements as to the scaffolding jumping is manifestly untrue, correct? It's not as if there's an affirmative statement by him giving a different version of the accident.
Yes, there are affirmative statements, Your Honor.
What
it's not
that he says that is completely different from this action? What statement does he make other than not mentioning problems with the ladder, etc.? Where does he affirmatively state that the accident, that there was nothing wrong with the scaffolding?
In each of both the accident report, in the C2 form, in the C3 form, and in his report to his chiropractor, all of those statements don't simply fail to mention a fall, they affirmatively mention that he stepped down off the scaffold onto the deck.
Sure,
That's-
and that's
that
what he
is a
did.
different
That's
action.
exactly what he did. He stepped down. What he doesn't do, he doesn't mention the fact that the scaffold allegedly jumped a little bit, correct?
Right.
Correct, he didn't. He mentioned that he stepped down off the scaffold and then fell.
That's not completely, that's not manifestly untrue, or it's not physically impossible to happen, as Judge Acosta suggested. Isn't that sufficient to go to the jury to determine what precisely happened on the date of the accident?
Or at least to draw a difference between stepping down and plaintiff's own EBT testimony of a fall, quote unquote. So is a fall inconsistent with stepping down? I don't know. I mean, maybe a jury will feel differently than you.
Yes, but Your Honor, these inconsistencies were explored at length with plaintiff during his deposition. He was confronted with each of these pre-litigation statements. He confirmed that all of them were accurate, and we went over the difference between a step and a fall, pointing out that a step was the action used in each of these statements, never mentioned a fall. And
Well,
these
that sounds like great cross-examination at trial, but you want us to decide these issues as a matter of law, that somehow describing it as a fall or describing it as stepping down, that those two are manifestly inconsistent.
Well, yes, Your Honor, because this court has held that when plaintiff's bare testimony is all he has, and it's not supported by any other evidence, and is in fact refuted by documentary evidence submitted by defendants, summary judgment in favor of defendants is warranted. That was the holding in Broody versus Gibco Enterprises Limited. The court also must discount plaintiff's testimony when he's relying solely on his own testimony, uncorroborated by any other witnesses or evidence. In this case, Your Honor, all the other witnesses that testified all stated that there was no issue with the scaffold, that there was no repairs required to the scaffold, no adjustments, nothing had to be done to the scaffold after the accident. And so here, plaintiff has nothing else to rely on except for.
So plaintiff's testimony is not evidence?
It is evidence, Your Honor. However, this court put forth a test for when documentary evidence can completely refute testimony. That was in the case VXI Lux Holdco Sarl versus Stick Holdings.
Well,
in that case,
Mr. McLaughlin, I mean, the documentary evidence that you're talking about is that he didn't mention certain things, like he didn't tell the doctor exactly what happened, or there was no place else where it was. Rather than affirmative, it's documentary evidence. It's almost as though, well, he's the only one that saw it. He didn't tell his doctor, so I didn't mention at least at first. So that's documentary evidence, and maybe that's, as Justice Acosta said, very good cross-examination for you at trial, but maybe not documentary evidence that absolutely precludes the plaintiff's claim.
it's not just the failure to mention a fall. It's the affirmative statement that he stepped down onto the deck. That is a different action than a fall. And plain meanings, it doesn't.
Could he have been stepping down and fell?
If he did, that's not what he states in these pre-litigation statements. He says he stepped down onto the deck. He's not talking about stepping down and then missing a rung and falling. He's talking about stepping onto the deck and then feeling pain in his back.
Okay, thank you, Mr. McLaughlin. Let me hear from the responding in this case.
Thank you, Your Honors. Scott Singer, I represent the plaintiff respondent. The basic principle, as the court is well aware, was articulated. There's a recent case, Carthen against Sherman, where the court said that the contradictions in the testimony of the respective parties raise issues of fact for the trier of fact to resolve. That's exactly the situation we have here. And incidentally, they were had two briefs to find a case where summary judgment was afforded defendants in situation akin to the one at bar, and they didn't provide any.
Mr. Singer, what about your adversary's point that there's a distinction to be drawn between stepping down and falling 4 to 5 feet?
Well, there is a distinction. I mean, first of all, the plaintiff was stepping down when he fell. Second of all,
but he didn't say that. I think that what the defendant was saying, but that's not what he said. In his pre-litigation statements, he said nothing about the fall.
these were 1 or 2 sentence references in accident reports. They weren't an exhaustive description of the accident. And frankly, plaintiff is not a lawyer. He's not particularly articulate. It doesn't view terms the way we necessarily view them with that kind of precision. And he explained that as far as he was concerned, he's seen guys fall 30 feet. He considers that a fall. He didn't consider it a fall. So it was perhaps 4 feet, 4 to 5 feet. So he didn't consider that significant enough to term as a fall. There are 4 accident reports and the health report. They're not entirely clear. It's a little bit difficult to make out exactly what he's saying, but he did say he stepped down. In fact, he was stepping down when the accident occurred.
And what about, would it be fair to say that his version of the incident was physically impossible? And now I'm referring to the scaffolding moving a little bit, because other witnesses say that, it's totally fine. There were no problems with it. Nothing had to be done to it.
Well, it wasn't. That doesn't mean it was physically impossible, Judge Singh. I think the point is that he said it moved. Clearly, if it moved, it didn't provide proper protection. And there's no biomechanical evidence or anything else saying it was physically impossible for the accident to happen this way. And but I'm glad you mentioned that, because of the 5 cases that the defendant's relying on, 3 of them, the court specifically find it is physically impossible for the accident to have occurred this way. D'Orazio, Laughlin, Hardy, all those cases, the court, in addition to whatever other factors there were, focused on the fact that it was physically impossible, and there was proof that it was physically impossible for the accident to occur the way it happened. Nobody is saying that it was physically impossible. And just as long as we're mentioning it, the other 2 cases, Brody and Castro, Mr. McLaughlin mentioned Brody in his presentation. Those are cases where there were photographs that completely belied the plaintiff's account of the accident. There's nothing like that here. Those are the kind of cases where the court will afford a defendant summary judgment, where there's physical impossibility, or where there's photographic evidence that definitively establishes that the plaintiff was not telling the truth in his description of the accident.
And that was the photographic evidence in Castro, right?
Yes, Castro and Brody, there was both definitive photographic evidence that refuted the plaintiff's account. And this is not, also that the court is aware, there's dozens, maybe hundreds of cases in which a plaintiff testifies and then he tries to get around his testimony with an affidavit that was tailored. That's not the situation here. The plaintiff never testified. He made some remarks. In his perhaps inarticulate way, he tried to describe what happened, but there's nothing, as the court recognizes, that's great cross-examination material. And as the Supreme Court recognized, this is a pure question of fact case that has to go to the jury. We're not asking for summary judgment. It's a question of fact case, and it was correctly decided in that respect.
Thank you, Mr. Singer. Mr. McLaughlin. Go ahead, Mr. Singer.
Just the 240 and 241-6, their arguments are totally predicated on their assumption the plaintiff did not fall at all. So he did fall. So thank you very much, Your Honors.
Thank you. Mr. McLaughlin?
Yes, just 2 quick points in rebuttal, Your Honors. First, plaintiff does not need to be a lawyer or have any legal understanding in order to know the difference between the terms step and fall. These are plain meaning, simple terms that everyone knows the meaning of. And it's not enough for plaintiff to say, well, I think a fall is 30 feet. A fall does not have to be at least 30 feet to be recognized as a fall, especially when you're reporting an accident. You should know that if your accident is a fall, you should be able to say a fall and not a step. So these are unambiguous terms. The pre-litigation statements are indisputably authentic. Plaintiff himself said, yes, that's what I said. That's an accurate description of my accident. And they're undeniable. He was challenged with each of these statements at his deposition, and he did not deny any of them. Those are 3 elements that this court has held are required in order for these documents to refute his testimony. And finally, Your Honor, just on the point of there's no photographs here. There's no photographs here because plaintiff waited 5 days before he reported this accident at all, this unwitnessed accident that no one saw. Thank you.
Thank you. Thank you both.
Thank you, Your Honors.
Next case is Saket
Good morning, Appellant ready. Good afternoon, Appellant ready, Your Honors.
Go ahead. Counsel for Mr. Saquet. Go ahead, Appellant.
Yes, may it please the court, Mike Anton Giovanni, Meyer Swazi, English Inclined for the plaintiff, Shilpa Sacketh Realty, Inc. Your Honors, the lower court erred in dismissing this complaint based upon this release, the validity of which is factually disputed by the pleadings. Because it was factually disputed by the pleadings, it cannot serve as documentary evidence to conclusively resolve these issues as a matter of law and establish. I'm sorry, Judge Singh.
Judge Singh has a question.
I have a question for you. We've all read the record, so so this is the issue, at least in my mind. I mean, first of all, what plaintiffs did was incredibly negligent. Obviously, they didn't read documents, signing releases without looking at all the documents. So the question is, at the pleading stage, at this stage of litigation, can the plaintiff be excused from not reading documents that they should have read? And if so, why?
Absolutely, Your Honor. The general rule is that a person is bound by the documents that they sign. However, there are exceptions to that. And one of the exceptions is applicable here, where a confidential relationship is alleged. A confidential relationship is alleged very clearly in the complaint between the respondent, Vidialia, and Shilpa Reddy, who is one of the principals of SSR, the entity. She referred to him as uncle. She grew up thinking of him as a family member. She totally entrusted him. These are the allegations of the complaint. They have to be accepted as true for purposes of this motion to dismiss.
Well, what about the fact that Vidiala was also the attorney, in fact, under the agreement, responsible to get executions from other minority shareholders? Would that be a basis to say that there's some kind of some kind of fiduciary relationship?
Absolutely, Your Honor. He's wearing a number of hats. Number one, there's the confidential relationship, which is separate and apart from the fiduciary relationship that he holds, because he is a shareholder of Invigen. He's a co-shareholder of Shilpa. That this is a close corporation. They owe each other fiduciary duties in that regard of disclosure and loyalty. But in addition, as you pointed out, under the agreements itself, he's an agent in fact for, I'm sorry, Judge.
That fiduciary relationship doesn't relieve him of the obligation to read a document like a general release, for example, that itself says what it is, right?
Well,
the signature page for the general relief says what it is.
So Vidialia, just days before the closing, emails just signature pages of the closing documents and asked them to sign it. He doesn't provide the document. She is entitled to rely upon him as a fiduciary and this confidential relationship in signing the documents. Yes, it says general release, okay, but she's a layperson. She's a medical student, 20 years old at the time. She's not involved in this transaction or the running of this company. She's completely relying on him. Just because it says general release does not magically impart to her or to a layperson what that means. Okay, so if you look at it in the context of what this is, even if she knew what general release is, and I think that's a big stretch because most lay people do not know, laypersons do not know what that is. But even if she didn't know what it meant, this context of this is the shareholders, Shilpa, selling their shares to a third party, Cipla. This is not a transaction between Shilpa and Vidalia and Shilpa and the other shareholders. So there's no reason for her to think that just because she's signing a document that just says general release, that should mean that she's therefore releasing Vidalia, who she's trusting, and all the other Invigen shareholders from their fiduciary responsibilities. Okay, so there is no reason to believe or suspect that she knew that. That's not the pleadings of the complaint. In fact, the allegations in the complaints are that he never explained what the documents were. He said he would provide the original closing documents, but he didn't, because just several days later, he closed the transaction, and therefore he impaired her ability to even read the documents. He closed the transaction with her signature page.
You said she was 20 years old at the time?
She was a medical student, yes, in her 20s, yes. Not represented by counsel, okay? She was not, she was She was not participating.
Well, wasn't
in the
her
running of
father, Dr.
Invigen.
Reddy, involved? And presumably he's a sophisticated businessman, right?
That's what they say.
Well,
in there.
that's what.
That's not part of
I
the
can
actual
assure you-
record. They
I can assure you, Dr. Reddy has a very big presence in India, so it's not that he's not an unsophisticated man.
I'm not saying that he isn't, but he was not involved with this company for many, many years. He had founded the company many years before that. He left the company. He went on to start his own company. And you know what? This really shows, this kind of gives a glimpse of what the motivation here for this fraud was, because they say in their papers and their counsel's affirmations that, you know, well, Dr. Reddy left the company and he started another company, which was his absolute right, by the way. There was no non-compete or anything like that. And he therefore devalued Invigen. So this kind of gives us a glimpse as what the motive here was and why they decided to defraud Shilpa and why they took percentages away from her. And then they distributed it amongst themselves for over tens of millions of dollars.
So actually, what is your claim precisely with respect to that? The transaction was 500, but in fact that there was fraud with respect to the 100,000, the million, excuse me, and they didn't get their pro rata share of the 100 million. Is that your claim?
That's right. That's right.
Okay.
They were entitled to 9% of the 500 million.
Thank you, counsel. Let me hear from the respondents in this case.
Good afternoon. Ronald Lefton, Isaiah Feldman for the respondents. The appellant's argument on appeal is brand new. It was never raised below, and it is completely contrary not only to the stock purchase agreement and its exhibits and schedules, it's contrary even to their complaint. The complaint makes no reference to the release whatsoever. The complaint makes no reference to any claim with regard to the release or the officer's certificate.
Counselor, this is Judge Singh. Let's step back a minute. The argument is essentially there's a confidential relationship between the principals of the plaintiff, right, based on some sort of familial relationship, old friend relationship, and also that there is that your client is the attorney in fact. And there's a fiduciary relationship there. So why don't you address it in that context?
Sure, Your Honor. First, the fact that these people knew each other does not create a fiduciary relationship with respect to the separate negotiation of the allocable share. The entire structure of the agreement is that the $500 million in sales proceeds was going to be paid not based upon capitalization and the number of shares owned, but rather based upon a separate agreement to be negotiated among the shareholders, the allocable share agreement. And that allocable share agreement is a one-page schedule. It's in the stock purchase agreement in two different places. And the complaint alleges that that agreement was negotiated by the plaintiff's agent, their father, Dr. Reddy, a sophisticated businessman, a contemporary of the respondents, well familiar with this company, which he had formerly been the CEO of. He negotiated that agreement, and the appellant got exactly what he negotiated. Their complaint is that the 100 million did not go to Camber, but instead was split among the other shareholders. It's obvious from the face of the documents that the shareholder, that Camber was not a party to the stock purchase agreement, was not going to get any proceeds. That's in the very officer's certificate.
Are you denying that there were representations made that the 100 million would go to Camper?
Yes, I am, but I don't think that's relevant here.
Right, because of the posture of the case, right? So we have to take it as true.
In fact, not only do I deny that, but I also deny that they did not get the documents. They did get the documents, and they did have counsel, and their counsel communicated with the counsel for Invigen, the seller.
But doesn't that really go, Counselor, doesn't that really go to summary judgment as opposed to on a pleading stage motion where the allegation is that there is either a confidential or fiduciary relationship, and then the question is does that in any way excuse the plaintiff from not reading documents which no one will dispute in this room that they should have read?
As this court acknowledged in the Sanchim Realty case, 299 AD 2nd, 220, First Department, 2002, the mere existence of a fiduciary relationship does not absolve a plaintiff from the failure to read. These people had every opportunity to read, and remember, Your Honor, they had the leverage. They did not have to deliver that executed signature pages. They did not have to, until if they had any questions, they could have looked at it. There's no allegation that they ever asked.
I don't think that we're disputing that. I mean, you involved in a $500 million transaction, you should be reading documents. The question again, to go back to Justice Singh's question is, given the nature of the relationship, and even Solis and a lot of the Court of Appeals cases and this department's cases, really it's all depending on the nature of the relationship, right? And whether there was reasonableness in terms of relying on the individual who's making the statement or doing the representation.
And respectfully, Justice Ostrager was 100% right when he said that it was unreasonable as a matter of law to blindly read.
But is it
to not read?
Mr.
Yes,
Lefton, aren't those issues usually that we don't decide on a 30-11 motion to dismiss, the reasonableness? I mean, we all know what happened here, what's alleged to have happened, but this is just a 30-11 motion. And so we're seeing what they said, and they're saying, I mean, the reasonableness of their reliance on what a family friend and somebody who is supposed to be responsible for the actions of the minority shareholders, which the plaintiffs were, that reliance might not be something that we should be deciding now. You may win the case, but now on a 30-11 motion is what I'm concerned about.
But Your Honor, this is not something that requires a factual record. These are all issues of law. First, the minority representative status did not go into effect until after the closing because it had to do with a narrow range of issues which were all post-closing. Second, there was no fiduciary duty with respect to the negotiations among the shareholders about how to split up the sales proceeds. For that purpose, they were all looking to get the most they could get among themselves.
So in other words, it was a free for all,
no...
Counselor, in other words, you're arguing it was a free for all and that they were all looking after their own interests, correct?
Correct, and they were also equally sophisticated because Dr. Reddy did these negotiations.
But is that consistent with the allegations of the complaint that this was a joint negotiation, et cetera?
I don't think the complaint really addresses this specific issue because the complaint says that Dr. Reddy went to India and negotiated how the sales proceeds would be allocated, and he agreed to a specific reduction. And that's exactly how much they got. And if they had, even if there were a fiduciary duty, these are not illiterate people. These are not people who can't read English or speak English. They're not victims here. They were represented by a sophisticated businessman. He could have easily looked at these simple documents. The release is just a few pages. The shareholder allocation schedule is a single page that sets it all out. The documents are not complex and they are clear on their face. It's not that something was hidden here. It's that the plaintiffs ignored their duty. They chose not to look. They chose not to read. They chose not to inquire. They never once even alleged that they asked what the other shareholders were getting. They claim that Amber was
Mr. Lefton, your time has gone way over. Mr. Giovanni, you get 1 minute rebuttal.
Thank you, Your Honor. I just would like to make a brief point. I think Your Honor's hit the nail on the head that you really have to remain focused on what the standard here, because this is a motion to dismiss, and a lot of the arguments that respondents make here and made on the court below are arguments in connection with more of akin to a motion for summary judgment, not on a standard where every inference and all the facts that are alleged in the complaint are deemed as true.
How about, Counselor, how do you respond to your adversary's point that the shareholder allocation, that was separately negotiated between the parties, and that should actually, in essence, end the case based on that allocation?
Yes,
So
Your Honor. That was my next point. That's completely untrue and is refuted by the allegations of the complaint, because the complaint says that the parties agreed that they were going to distribute the sale proceeds according to their ownership interests. It was a mechanical formula for distributions. That's the way it was set up initially when it was a $500 million deal. And that's the way it was agreed that they would continue it when Bandy and Vidialia made the misrepresentations regarding taking $100 million out of the deal. They were still going to do it pro rata. That's part of their that's part of their misrepresentations. They said, yeah, we're going to share in this pro rata. And that was the same. So there was no negotiation between the shareholders. They want to cast it as if there was one, because they know then, if there was some sort of negotiation that would pit them against each other, then that would cause cracks in the fiduciary relationship. But that is not pled in the complaint. To the contrary, the complaint is that the shareholders were completely aligned.
Thank you, Mr. Giovanni. Thank you. Thank you both.
Your Honor, may I just correct something that he said on rebuttal?
You don't have,
contrary to the SPA.
Counsel, we've read the record. We've read the complaint. You don't have rebuttal time. Thank you both.
Thank you.
Okay, Green versus Rayner Lane Property.
Yes, Your Honor. Ed Guardaro, Fullerton and Beck for SDC Sukert Dow LLC.
Yeah.
If Your Honors, please.
Plaintiff. Okay.
If Your Honors, please. Your Honors, I would argue to the court that this claim doesn't fall within the confines of 240 of the labor law. The trial court's determination that it's either a falling object scenario or significant elevation scenario or a load that requires securing is undermined by a series of cases from this court, Court of Appeals, the Second Department, and chronologically going backwards, Jackson versus Hunter Roberts, 161, 666, the plaintiff's carrying a water pipe. He loses balance on a makeshift ramp that bows or drops.
Counselor,
he drops the pipe.
Counselor, a lot of the cases that you cite, the ground below is flat. In this case, there's some evidence that there was a slope to the ground. Does that change the analysis?
With all due respect, Your Honor, I would say no. In Jackson, German, and Carrera of this court alone, the court stated that the impetus of the pipe's descent or the load's descent was the plaintiff's loss of balance, not gravity. So labor law 240 doesn't apply. In German, this court affirmed the grant of a summary judgment to the defendants in 240. And in that case, there was a wet metal grate, and the grate, he had to be lifted up. Now, the court's talking about a slope, but for instance, in Carrera, the plaintiff was carrying a metal pipe and he slips on muddy ground that's pocked with rocks and stuff. So it doesn't say this court specifically in both Jackson, German, and Carrera have never articulated that there might be some slope. The issue is, as the court has repeatedly said, is whether or not the descent of the material and the loss of balance was not based on gravity. And here, it's obviously not. Plaintiff's testimony, whether he slipped before he lifted or he tried to lift, it doesn't really matter. In Carrera, Justice Acosta was presiding over that. This court reversed the denial of summary judgment, like in a situation like this, where the plaintiff and his colleagues were carrying a metal pipe and he slips on the ground. It's wet, it's muddy. It sounds somewhat similar to this scenario, but both in that case and in Jackson, the device hits the ground and then bounces back and hits the plaintiff. In this case, nothing ever hit the plaintiff. So whether or not
do you think that Mr. Guardaro is the distinguishing point, that nothing ever fell on him or hit him? It was just that he, if I understand it correctly, he testified he slipped because the ground was muddy.
Yes, Your Honor, I would submit that is also a distinguishing factor. That was seen, in Jackson and in Carrera. That's not here. The German case doesn't necessarily have a situation that something bounced. It was a heavy metal grate. In the second department, it's very similar. It addresses Justice Singh's determination question. In Sullivan versus the New York Athletic Club, the court might be aware the second department 2018 determined that summary judgment should be allotted to the defendants under the circumstances that the plaintiff is carrying a beam on his shoulders with his colleagues again, and he hurts his knee while he's walking down steps. Again, it's
see what I don't understand is what I don't understand is the focus on the object striking the plaintiff. That's not what, like, for example, what Runner talks about, right? Runner talks about an elevation differential. And the question is, I mean, particularly when you're talking about a 500-pound object that's required to be lifted, did the plaintiff fall because it was muddy, or did he fall because of something else, because of that 2-degree elevation? I mean, isn't it just the force of gravity that we're talking about, rather than the object itself striking the plaintiff?
Your Honor, I would agree with you that whether the object struck the plaintiff is a side issue, but I would also submit that it's not a question of gravity here. What Runner said is that the plaintiff has to prove that the protective device proved inadequate to shield the worker from the harm directly flowing from the force of gravity. And in all the cases that this court has determined, which I articulated, as well as the Sullivan case, where the plaintiffs
but wasn't he, I mean, can you expect a plaintiff without harness or without any safety device to lift a 500-pound piece of wood in order for the force to put in the blade in it?
Your Honor, I'm going to assume all facts in favor of the plaintiff under the circumstances for this case. Right. But I think the court should recognize that on page 337 of the record, on lines 18 to 23, the plaintiff squarely says, if I had 2 sure feet on the ground, it probably would have been okay. This goes to Justice Singh's determination, but it also goes to your question about whether or not we're talking about gravity. It had nothing to do with gravity. It had to do with the fact that he slipped on the ground, and he's admitted to that. Whether he was lifting or not, these other cases determine that, Your Honor, I see I've used up my time. I'll reserve the rest for my rebuttal. Thank you.
Thank you, counsel. Let me hear from Cross Appellant Haddock.
Thank you, Your Honor. May it please the court, my name is Matt Minero. I represent Haddock. Your Honors, my argument piggybacks Mr. Gordaro's argument. We don't believe that this was a Labor Law 241 claim, and if there is no Labor Law 241 claim, the contractual indemnity finding against me, it effectively goes away because we have been paying the defense of the general contractor SDC. But in terms of the plaintiff's claim itself, we agree with Mr. Gordaro. I mean, there's really nothing more to say.
Mr. Minero, are there any remaining causes of action on behalf of the plaintiff other than this 240 subsection 1 labor law claim?
No, Your Honor.
So the others have been dismissed, or they're just not in the case anymore?
They've been dismissed. Labor law.
Well, the 240. Yeah, no, I'm just looking at part of the record here and whether plaintiff's cross motion for partial summary judgment have been granted. That was just on 240?
Just on 240, yes, Your Honor.
Okay.
Thank you.
Okay.
Unless Your Honors have questions.
No, I think we're good. I think we're good.
I think so too. Thank you.
Let me hear from respondent in this case.
I think you're on mute, Mr. Tulchin. I can't hear you. No.
No.
Uh-oh.
Yeah, can we unmute
Well,
Mr. Tolchin?
it doesn't look like he's on mute, but it does, we can't hear him nonetheless. Maybe
Yeah.
your microphone's turned down and maybe the volume's turned down?
Oh, I see that he's in a mute.
Oh,
He is muted. Okay. On the application itself, Mr. Tolchin, you may find when you put the cursor, there you go, there you go. Yeah, I see you. Yeah, no, even when you unmute, we can't hear you. You want to call in immediately? Why don't you do that right away? I'll give you 30 seconds. No pressure. You dialing in through Teams, Mr. Tolchin?
It's frozen now.
Is he frozen or?
Yeah.
Yeah.
He's calling.
he's calling.
Hello, can you hear me now? I'm sorry.
Yeah, that's
Yes.
okay. We can hear you, Mr. Tolchin.
All right, you can hear me. I don't know if you can see me. Can I just
Yeah.
begin then? Justice Kapnick, you had
Yeah, we can both hear you and see you.
beautiful. Sorry, this happened to my
That's
adversary
okay.
2 weeks ago with the exact same thing, but to him now it's fair play, I guess. Anyway, Justice Kapnick, you mentioned, didn't he just slip? He didn't just slip. Yes, that's what caused him to fall. But the fact that he had 1,000 pounds of pressure pushing on him is what caused him to fall and the injury that he sustained to his back. He was trying to hold it up, but it was too much and it fell down and it did fall. I can't hear you, Justice Singh.
You're right. Right. How do you distinguish the cases cited by your adversary, where there are similar facts, especially the second department? Other than this being in the second department, how do you distinguish the case of a guy coming down the stairs and he hurts his knee? How is that any different than this case?
None of those have anything to do with this case, because in this case, he was provided with an inadequate device for hoisting this 1,000-pound load.
Well, he actually had no device that day. Is that correct?
Well, he had a lull. They told him you have to use this lull, the forklift. You have to use the lull, and there's no other way. Don't use anything else. They didn't give him a jack to lift it up. They didn't give him chocks or anything or a pulley to lift it up. He had to use his own hands to lift it up. And it was an inadequate device that he was required to use for the undertaking. This is exactly what Runner says is protects the plaintiff.
Yeah, Mr. Tolchin, you also agree, this is Justice Acosta,
Yes.
you also agree that whether the object actually fell on him or hit him is of no moment, in as much as we're really talking about the force of gravity causing the injury.
That's correct. And it did fall, well, it pushed on him. He's holding it in his hands and it's pushing on him. There's contact with him. And it's the force of gravity that pulls him down, that pulls it down on him. So,
And,
yes,
and how is
exactly
this
right.
an elevation related risk?
Well, as opposed to being a de minimis, because the force of 1,000 pounds working on him.
So you're saying the elevation here is the piece of lumber, not the slope?
Right. Well, right. Yes. The elevation is he's lifting up the bar of the 1,000-pound object about 12 inches and holding it up, and it wants to push down because it's 1,000 pounds, so it wants to push down, and that's an excessive load for one person to hold.
But isn't that just, I mean, heavy objects like that being lifted in construction sites, isn't that a usual risk of construction work with respect to lifting that heavy 500-pound object?
Well, I'll answer it this way. No, it's a device that was provided that he had to use that he could not use because the forklift itself didn't have an appropriate mechanism to load itself. It required a human jack to lift it up instead of an actual physical jack.
So the protection that he required against the elevation differential, the device is whatever it is that's going to help him or assist them in sustaining that force of gravity, the weight of 500-pound lumber.
Yes, that his job was, you got to lift that freaking thing. And between you and me, I don't think the foreman said freaking thing. I think he used a different word. But this is the rated PG-13 version. He said, lift that freaking thing so I can get the blades under it. He didn't want to get out. He wanted to go quickly. He wanted the work to progress, and he didn't want the plaintiff to be going anywhere to look for anybody else. And there was no other person. It was him and Nick, the foreman, who told him lift that freaking thing when he wasn't supposed to be doing it, and everybody knew he wasn't, but they didn't give him a proper device to lift it.
Now, Mr. Tolchin, in his EBT, he says the ground was muddy, foot slipped a bit, yes, and that's how the injury occurred. In his affidavit, in the cross motion, he says, I raised the beam and immediately felt burning and tearing sensation in my lower back. Are you saying, and I'm not going to get caught up as to whether there's, there are issues with respect to both statements, but are you saying under the second version that would still be an elevation risk because it's the picking up of the beam?
Yes, the muddy, slopey ground did not help him.
So, but wait. So, but in the cross motion, in his affidavit, he says he raised the beam and then immediately felt burning and tearing sensation, right?
Yeah, well, he raised the beam. I think
So just using that, is that a 240 Prens 1 case?
That he raises it, without the slippy part?
Yes.
I would say so, yes.
Okay.
It doesn't have to slip. The fact was, if he was a device, he wasn't properly placed and operated because they only gave him a slippery thing.
And again, the elevation related risk you're saying here is picking up the beam.
Picking up the beam, yes, that's the force that forced him.
So that's the weight of the object using the force to cause the accident. I mean, that's runner language.
Yes, exactly.
Okay. Thank you, Mr. Tolchin.
Thank you.
Let me hear from cross appellant. You get 1 minute.
Your Honor, this is Ed Guardaro for SDC on reply. Your Honor, I would submit that all of this is well and good to sort of make things up, but the fact is that in Jackson, the water pipe that was being carried by several men, several hundred pounds. The estimate was somewhere between 500 and 700 pounds in Jackson. They had to pick it up, literally pick it up and move it.
So several men for 700 pounds. One man without any harness or jaw hoist or any device whatsoever to pick up 500 pounds, right?
Well,
in
no,
a slopey, muddy ground.
Your Honor, the testimony is he didn't have to pick it up. I'm not going to argue the facts. The facts are the facts. But what the testimony was,
do you
had to wrestle it.
Mr. Tolchin's ascension that basically the person he was working with just asking him to pick up the freaking thing, and it's not like an offer of a harness or something else was made, right? He was just asked to pick it up, and he did, and got injured as a result.
He never picked it up, but be that as it may, even in Carrera, in which you presided, Your Honor, the metal pipe they were carrying was hundreds and hundreds of pounds, So if there was ever a scenario, just like in Sullivan, where you needed something, but the courts have repeatedly said that that's not what Runner versus New York Stock Exchange states. This court has repeatedly said it's not a direct consequence of the failure to provide an adequate protection. In this case, they had the lull. My adversary admits they had the lull. They've been using the lull.
Do you remember what the differential was in Carrera with respect to? I know that the plaintiff tripped and he causing the pipe to fall, and the pipe struck him. I don't remember what the elevation was or the weight of the pipe.
They had according to the decision, at least, they had the pipe on their shoulders. The men had the pipe on their shoulders.
But it was more than one man, right?
It was. I believe it was he and one other man carrying this huge pipe. But I would submit that just like in Sullivan, the courts have repeatedly said in a situation like this, it's not a gravity-related scenario.
Is lifting the beam an elevation in itself an elevation-related risk? I mean, is that how we analyze elevated relation risks?
I would submit it is not, Your Honor. It is not under the circumstances, because he was not under the circumstances, very particular circumstances. He didn't have to lift the beam. He had to shift. The testimony is they wanted to shimmy it onto the forks of the forklift. He wasn't being asked to lift a 500-pound beam.
Isn't that semantics? I mean, in order to shimmy, I mean, it had to be moved up a little bit so they could get the forklift under it. So, I mean, it wasn't like he had to pick it and hold it over his head, but he did have to move it up. He had to, he had to move it. So whether you say lift it or, I mean, it sounds like it's a semantic discussion here.
Well, Justice Kapnick, that's why I've steered away from those facts. I'm not debating those facts. It's not appropriate to do so under the circumstances in my burden of proof. It's not. I'm arguing that as a matter of law, in other circumstances that are very, very similar to this, the courts have repeatedly, relying on Runner and Ghani, another great case. You're talking about holding a rock, and walking over sloped ground and tripping on another rock. The courts have said that is not an elevation-related situation.
Okay. Thank you very much, Mr. Guardaro.
Thank you.
Mr. Monero, you won your 1 minute?
Yes, please. It's just my one comment is where are we going to draw the line here as to what becomes as a matter of law something that's too heavy? Is it going to depend on just the object itself? Are we going to?
But this is not where we're going to draw that line, right? I think we can all agree that you don't ask one man to lift or to move a 500-pound object. I mean, I know heavy weightlifters who cannot do that.
Respectfully, Judge, you're correct, but there may be someone who can. But then there's people who can't lift 200 pounds. There's people who can't lift 200 pounds.
But I guess my point is that that's really a factual evaluation by the trier of fact. I mean, at what point, how much is too much? Am I required to provide a hoist or another type of device under the circumstances? That's all factual. That for us to find as a matter of law that assuming that there was elevation and assuming that the fall was caused by the slope, muddy ground, whether that falls more on the runner or more on some of the other cases that you and your colleague have cited. But I thank you very much.
Thank you. Thank you, Your Honor.
Thank you, all three of you.
Sorry
Thank you, Your
for
Honor.
Technical problems.
Old Terra and Discover Property versus the NFL.
Yes, Your Honor. May I proceed?
Yes,
I don't think there was a pro hoc DJ.
Yes, Mr. Dolan is submitted. He's from your Covington office in DC, right?
Correct.
So the application, the prohibition application is granted.
Thank you, Your Honor.
Go ahead. I'm sorry to rush you through. It's just.
No problem. Good afternoon, Your Honors. May it please the court, Heather Simpson on behalf of the appellant insurers. The insurers submit that the court below erred by analyzing the duty to cooperate and the common interest doctrine independently. These two concepts must be considered in tandem and based upon the facts that are presented. New York law consistently enforces the duty to cooperate as a valid contractual obligation and condition precedent to coverage under insurance policy. It is a compulsory.
But the question is whether those cooperation clauses operate as a waiver of the NFR's attorney-client privilege and work product protection, right?
Your Honor, we submit there is no waiver of a privilege between the insured and its insurers. As we note in our paper,
suggesting that you're not in an adverse position in this litigation?
We are in an adverse position in this
litigation.
Then
how in the world is there a common interest in this litigation?
Your Honor, the common interest started even before this litigation by virtue of the fact that the NFL is seeking substantial coverage from my client and many others. And many of us, including my client, the Riverstone insurers, have agreed to participate in the defense. And we've incurred over $20 million in defense in that case. My client alone has paid over $50 million.
Initially, the NFL was denied. In fact, the response was that the insurance didn't want to offer a defense, and in fact, reserved rights and outright rejected the liability coverage and obligations. So I don't see where the
Sorry to interrupt. That is a mischaracterization of the history of the positions of the insurers. There has been no denial of coverage here.
Well, okay. Let me ask it this way then. What's the basis of this DJ action?
The DJ action was not started by my client or any of the appellants here.
Well, the insurers. Why are the insurers seeking a declaratory judgment?
Well, the insurers are seeking a declaratory judgment because the NFL came to all of the insurers seeking defense and indemnity for what is now an unprecedented settlement that will pay upwards of $1 billion plus over the course of 65 years.
And you agree with the NFL that you should pay it?
Your Honor, we have reserved rights just the same way that the NFL has reserved rights and asserted defenses in this litigation. We have too.
So
your interest is different than the NFL's, isn't it?
Excuse me?
Your interest is not clearly aligned with the NFL's interest.
Our interest with respect to the underlying defense and the materials we are seeking was absolutely aligned with the NFL. We had
but that's not the only thing that you're looking for in this case. I mean, it's a funny kind of a situation. I mean, no one's saying that you're not entitled to any discovery at all in this case. There certainly are things that you're entitled to, but your DJ action is trying to figure out whether or not, you just said it was an unprecedented settlement, a huge settlement. It goes out, I think, 65 years, potentially. And so it is a lot of money. You're trying to figure out whether it's justified, whether you have to indemnify in a complete way. So you really have to admit that you're in an adversarial position at this stage with the NFL. And you're trying to figure out whether you need to indemnify them or not, whether maybe all the defenses you need to put up or not. And so how could you ignore the fact that you're in that kind of position in our kind to determine whether or not they still have the right to their attorney-client defense and work product privileges?
Your Honor, under the contract, they have a duty to cooperate. It's compulsory.
I understand
it's not voluntary. Your Honor, if I may.
But it is cooperating, meaning equivalent to their waiver of their attorney-client privilege and the work product they've developed as part of that privilege. That's the question, right?
Right. The work product that my client and other insurers have paid over $20 million for, and we've seen.
But that's not the test, right? It's not whether you pay for it or not. It's
Your
whether
Honor,
your interest, nevertheless, is different.
They had a duty to cooperate from day one. We had a common interest in defense strategy and settlement strategy. That continued. And the case law suggests in New York that simply because we later become adversarial in this litigation, which was not started by the insurers that are appellants right now, there's still a common interest that supports the disclosure of these materials. They're in fact the only materials that will help us litigate the claims and defenses at issue here. There was no underlying discovery, there was no underlying depositions, there was no motion practice, there was no trial, of course. The only way we can evaluate the underlying settlement strategy, whether it was reasonable, they've alleged that we've acted
Counselor,
badly.
can I ask you a question with respect to that issue? And that's something that occurs. Is what's the test for reasonableness? Is it an objective one? And if it's an objective one, why does it matter with respect to work product and confidential communications?
Your Honor, the NFL has tried to inject the legal standards for reasonableness of the settlement, which we would submit is not appropriate for discovery motion. However, in responding to their position, even if it were an objective standard, and we don't concede that that's necessarily the standard as they've articulated it, these pieces of information are absolutely relevant. How would one determine whether it's objectively reasonable to agree to an uncapped monetary settlement for 65 years for 20,000 plus class members without any information as to what the strength of the defenses were?
Ultimately, who makes the determination with whether or not the class action it should be accepted and whether or not it's reasonable? Isn't it the court? And does the court have materials in front of it to make those determinations?
The court in this action?
Not in this action, in the underlying class action.
The underlying analysis for reasonableness of the settlement is not the same standard as whether it was reasonable in the context of insurance coverage. The court, the Eastern District of Pennsylvania, the Third Circuit, they were looking out for the fairness and adequacy of a class settlement. They have obligations to the class to make sure that those claimants are receiving enough money. They weren't seeking to knock down those numbers. And in fact, Judge Brody increased the numbers.
Ms. Simpson, I agree with you that there can be some different standards between what the judge in the Eastern District was considering in the class action and what the issues may be between the NFL and its various insurers in this action. I can understand that. And nobody is suggesting that you're entitled to nothing and you just have to, pay out for 65 years without any evaluation. But somewhere in between there, our court has said, the First Department has said that cooperation clauses in the insurance policies do not operate as waivers of the insured's attorney-client and work product privileges, which is exactly what the issue is here. So why are they not entitled to assert those privileges when we've already held 8 years ago, this is it. And as a matter of fact, I'm the one that wrote the decision downtown that got affirmed up here. So I don't understand that law has changed since 2012.
Your Honor, the JP Morgan case that you're referring to is distinguishable from the facts here. That involved insurers that had denied coverage outright. None of the insured were defending. The insured had a $25 million self-insured retention that it had to satisfy before it would even get any insurance money, potentially. And there was a robust underlying record that was produced in the coverage case. There were underlying document productions. There were deposition transcripts, a robust record. And that's what Your Honor said in JP Morgan, that, you know, they still were required to produce all documents in possession relevant to the underlying claim. We don't have it here.
But has anyone said you're not entitled to any discovery in this case?
Your Honor, what we've been presented by the NFL is basically the public record. It's if they went on to Pacer and they printed out every document that was publicly filed, we do have that. We have press clippings, we have things produced by the NFL, but we do not have any analysis from defense counsel. And frankly, we have no communications regarding the settlement. We don't have mediation statements. We don't have communications with plaintiffs, negotiations, drafted the settlement agreements. Those are not even privileged, and the NFL doesn't dispute that. We are entitled to all of the defense file, but at the very least, there's a contingent here that's not even attorney-client material.
Okay, thank you, Ms. Simpson. Let me hear from Mr. Dolan.
You're muted, Mr. Dolan.
Thank you, Your Honor, and may it please the court. Mitchell Dolan for the NFL and NFL Properties. The portion of the appeal dealing with cooperation and common interest would overturn 30 years of precedent in this court, from U.S. Fire all the way forward to JP Morgan. Those cases are clear. They considered the contours of both the cooperation obligation and the common interest. And in a situation like this, where the parties are adverse, and I'd point out that the adversity began shortly after we provided notice. It continued a year after we provided notice, when the two insurers that are on the caption of this case filed these lawsuits that are now before you. That was filed by insurance companies here in New York. Ms. Simpson's client promptly filed cross claims against the NFL. That was the first rock that was thrown. Yeah. And make no mistake. Yes, sir. Yes,
yeah, Mr. Dolan, I mean, the question that I have, and I mean, I agree with you that JP Morgan stands for the proposition that cooperation clauses in the insurance policies do not operate as waivers of attorney-client and work product privileges. But JP Morgan doesn't stand for the proposition that the insurance company is entitled to no information. What I'm hearing from Ms. Simpson is that you basically turned over the public record, and they are entitled to a lot more in discovery in order for them to be able to make the proper evaluation.
I couldn't agree with you more, Your Honor. In fact, when the motion was filed, and they made a tactical decision to file the motion early, 2.5 years ago to be exact, the state of the discovery produced by the NFL at that time, and it's in the record, exceeded 700,000 pages. That doesn't count discovery they got from third parties. In the ensuing 2.5 years, now mind you, no depositions have been taken by the insurers yet. We're still in document discovery. We're appearing before the special referee tomorrow on a motion by Ms. Simpson and her clients. The record is very robust. It is more than 2x the size it was when the motion was filed. It is not limited to public record. But if we want to talk about the public record in the MDL court before Judge Brody and then before the Third Circuit, that did include motion practice. It did include 22 expert reports. It did involve a lot of pleadings, and the court did reach reasonableness. But we're not limiting them to that here. What they're trying to gather in discovery, and we're not resisting it, they are trying to get in discovery what the tort plaintiffs would have gotten if they had not settled. That's not privilege. If the tort litigation had continued, they wouldn't have been able to invade our privilege. They would have gotten information about what the NFL knew about concussions in the 60s, in the 70s, in the 80s. And that's exactly what the insurers are seeking in discovery here in other motions, and including involuntary productions by us that they've already gotten. And that's what they're going to pursue in depositions. They are going to compile a record in this case of discovery that will certainly exceed anything in Deutsche Bank, for instance. They point out that in Deutsche Bank, 120 boxes of documents.
Mr. Dolan, how significant? I couldn't tell completely by reading what I was able to read of the record. how significant amount of discovery that they're seeking falls into this privileged area that you've carved out.
Well, that's interesting. On the portion of their motion dealing with the so-called, what they call the defense file, which is never defined. And when they filed their motion, Your Honor, they didn't submit before the special referee a proposed order. And at oral argument, there's a colloquy, which we cite in our briefs, where the special referee wants to pin down, is this motion just about privileged documents that are at least facially privileged? Am I here to deal with exceptions? There was a colloquy. I presented the argument. We had a colloquy. No one disputed it. The judge, in his opinion, said that this motion deals with facially privileged documents.
I see.
And he ruled that's how the motion was presented, argued. And now so they're saying on appeal, well, we get the non-privileged documents in the defense file. Well, that wasn't part of their motion. We have produced a lot of non-privileged documents in response to other requests and other motions. And if they have something to say about non-privileged or never privileged documents, it's a matter for the referee.
Yeah. So you're basically saying this is the second quarter, right? So in terms
Great
of
reference there, Justice Acosta.
So we still got a lot to go.
Not a single deposition yet, and we're still producing documents. They're seeking discovery from all 32 clubs. That's in progress. They're seeking discoveries from individual owners. That's in progress. They've sought discovery from some 30 doctors that were involved in the evaluation of concussions. There is a very robust discovery record already, and it will only grow.
Yeah. Thank you, Mr. Dolan. Ms. Simpson, you have 1 minute in rebuttal.
Sure, Your Honor, we're not at the beginning of this case. We're into the 8th, maybe 9th year of this case. The NFL has tried to delay and avoid producing documents throughout this. We have, pursued it vigorously. The fact that we're pursuing discovery.
But Mr. Dolan is not incorrect in saying we still have 27 depositions to go. We still have all of the, I don't want to repeat everything he said, but there's a lot to go here.
The depositions, which we won't be able to take a thorough deposition without the underlying evaluation and investigation materials that we're seeking, that we're entitled to as insurers. That
so you can't do that without access to their privileged documents or work product.
It would be inefficient to do so, Your Honor, because those documents are highly relevant to the claims and defenses in this case, and therefore the questions that would be asked at deposition.
It may be inefficient, but that's not what JP Morgan talks about, right? These are privileged documents. There's an interest in protecting them.
JP Morgan and all the other cases cited by the NFL are either in the reinsurance context, with which this court has said is in stark contrast to the direct insurer-insured relationship, or involve situations where the insurers had denied coverage. None of the insurers here denied coverage. We reserved rights, just like the NFL did, and we've been defending for over 10 years. That is in stark contrast.
But those are not all the cases that Mr. Dolan cited were not just reinsurance cases. In fact, you cited JP Morgan yourself, right?
Correct.
JP Morgan's proposition.
JP Morgan, the insurers denied coverage. They did not defend. They did not seek to participate in defense strategy. My client sent, I can't even count the amount of letters that my client sent trying to get information about the settlement, about the negotiations. We were trying to be a partner at the table, and we paid over 10 years, over $15 million, just my client.
Counselor, but is that a meaningful distinction to invade the privilege?
Your Honor, again, I would say we don't view it as an invasion of the privilege. That's the whole nature of the common interest doctrine. The duty to cooperate is enforced by New York courts. It's compulsory. They have to share the information, and the common interest that we share in defending the underlying suits allows them to do so without waiving a privilege as to outside parties. So basically, we're under the mandates of the common interest doctrine and the duty to cooperate. The NFL has two options. It can either produce the documents and under the cooperation.
But Ms. Simpson, the underlying suit has been resolved. The class action suit is over. It's been approved. The only thing that's pending now is this lawsuit. I understand you didn't bring it. I don't think that's a meaningful distinction either. You now are on one side with the insurers, and the NFL is on the other side. And while I think you certainly should be entitled to certain things, this case is just about the privilege material. And I just, again, I think it's a semantic distinction as opposed to a real distinction. You're not, you have defended them, but now it's going to a next level and you're not on the same side as they are.
Correct, Your Honor, but that does not destroy the common interest that we have as an insurer that submitted a claim for insurance. And that's what Solomon Smith Barney says. That's what Goldberg says. And to Mr. Dolan's point, our motion absolutely sought not just defense materials, but the settlement materials. The name of the motion was motion to compel underlying litigation and settlement materials. We moved to compel document request number 29, 12 categories of settlement materials. And if they're not privileged, as Mr. Dolan says, why haven't they been produced? Why do we have to wait 8 years and fight tooth and nail to get them? So,
thank you, Ms. Simpson.
Thank you.
Thank you, Ms. Simpson. Thank you, Mr. Dolan. Great arguments. The Jorge versus Metropolitan Foods.
Yes, Your Honor. John Bonanno, Wiener Milo Morgan for the appellants, Metropolitan and Salem. Your Honors, I realize that we're running a little late here, so I'll get right into it. The underlying decision by Judge Silvera seemed to completely ignore the fact that my client's driver gave testimony indicating that he was not involved in this accident, that he did not make contact with the automobile. That is an overarching
argument. Did he testify that he was driving the truck on that day and that he was making a left at that intersection on that day?
Yes, he did, Your Honor. And as Your Honor, I suspect is probably familiar, this is a very heavily traveled area of the city of New York with numerous trucks, similar design on the interstate roadways, interstate commerce. There's also that area of the Bronx is heavily commercial, tons of trucks all over the place. The mere fact that my client may have been in that area on that day, making a turn onto a major thoroughfare that trucks use, which they're required to use.
But in this case, I mean, he's making the left onto the Deegan going south. I'm quite familiar with that area. I mean, the fact is that he didn't stop, and the plaintiff decided, or the driver of the car decided to follow him, took his the truck information, including the phone number, from his face, and also got the license plates, and that's how they were able to identify you. In fact, they called the defendant to find out, you know, basically to give him the information and exchange information. Isn't that the record?
Your Honor, I think that there's parts of that are in the record, but there's what I believe was an oversimplification in your summary of that, in that my client, number one, the story of the plaintiffs are that I mean, we're not even getting in yet into the issues of the BTL statutes, but their story is that they're sitting basically at a red light with multiple cars in front of them. The light turns green.
Well, they were there at the red light for 1.5 minutes, right?
Correct. But then their story is that they then went forward to the next intersection, made a legal U-turn, came back, which would have forced them to be in the exact same scenario that they alleged my client's truck was in, waiting for the turn signal to then make the left. And then mysteriously,
but they did that after they were hit, right? Because they needed to then go ahead and make the turn onto the Deegan South in order to follow the truck that had just hit them.
I guess what I'm trying to get at, Your Honor, is yes, they claim that they went forward, did a U-turn, came back, waited for that light to give them the go signal, then get on the highway, and then find the truck that they claim that in that split second they recognized. Okay, what I'm saying is it's very possible, and it's just as likely that they misidentified this.
So you're saying that would create an issue of fact, at least that issue, and that the judge overlooked that issue in considering not even about how the accident happened, but whether you were actually even involved in the accident.
Correct, and I believe I've heard in all the various other arguments that you point out that, you know, the other side may have a good cross-examination, they may have a good closing argument on certain facts, but at the end of the day, my client says they weren't involved in the accident, and that was completely ignored by the court. And that creates issues of fact, not just for the other driver, but the passenger who normally would not have issues of fact in a traditional accident. because they are not obviously operating the vehicle unless, of course.
But the passenger said that she saw the truck strike the rear of Mr. Jorge's vehicle. And she actually took down the information. It was she, the one that took down the information and passed it on to the driver. So now she's saying that she observed the truck strike.
I think that there does need to be some clarity here. My understanding of the record is that she took down the information after they caught up to the truck, and that they basically were able to, at that point, they decided, oh, that's the truck. That's what hit us. And here's the license plate, here's the telephone number, et cetera, et cetera. The problem is connecting that from the truck that makes contact is not there. And my client was very adamant in his testimony. Not only that, but he said he inspected the truck, that there was no damage to the truck. And obviously there should have been some damage, even if it was minor, there should have been some damage to the truck. You know, and the other thing is, they didn't, it's not as if they were,
for a second, going back to the happening of the accident, wasn't it the plaintiff's testimony that the vehicle was stopped at the intersection for a minute, waiting for the light to change? A white and green truck bearing the name Driscoll Foods turned left and then struck their vehicle on the rear side. So wasn't the identification at the time of the impact?
I don't believe that it said Driscoll Foods at the time. I may be, again, Your Honor, I apologize if I'm incorrect on this, but I don't believe that there's
your adversary will correct us all, so hopefully.
Also, there's a description of the truck that the rear of the truck is the one part that struck the car, yet they claim that there was transfer of green paint and only the front of the truck was described as being green, not the rear of the truck. So there are numerous inconsistencies here, and there's clear testimony. And just because there may be circumstances or facts that at trial the plaintiff could prevail doesn't mean that there aren't issues of fact here for the jury to decide.
Thank you, Mr. Bonanno. Let me hear from your opponent.
I'm waiting for the plaintiff's attorney. I would imagine he would speak first, but I am here, Your Honor.
Yeah, I don't know whether he actually checked in. He has 5 minutes.
He was having some difficulty.
Who's plaintiff's attorney?
I believe I see his symbol here, DK. I think that's him. No, maybe not. I apologize. I don't think that is.
Okay, why don't we hear from you, Mr. Greenspan, and then hopefully he'll join us.
If it pleases the court, Stuart Greenspan for the respondent, Sigfrido Jorge. From our perspective, I don't think it really matters whether it was the Metropolitan Foods truck or some other truck. So I'm not even going to involve myself into that fray. All I know is that my client is at a red light looking to make a left turn. Now, I think what Metropolitan is trying to bring us back into the case is based on a violation of VTL 1175. I'll call it a don't block the box statute. It's really designed to promote the free flow of traffic, to prevent gridlock. It is not designed for this situation. There are plenty of VTL sections that relate to right of way, that relate to keeping a safe distance. Keep in mind that the truck, be it Metropolitan or otherwise, was not impeded here. We know that he made a left turn. And if he had swung out wider or had been more careful, he would not have been impeded. So the violation of this statute was not a proximate cause of the accident. This car was here for over 1.5 minutes. The driver of the truck had every opportunity to see what he is required to see.
So under those circumstances, does it matter whether the vehicle is in the intersection or not because the vehicle is stopped? Is that all that's necessary to dismiss you from the case?
I'm not sure I understand you.
I'm saying, does it matter whether the vehicle is in the intersection? You make an argument that it doesn't cover the situation,
right?
But irrespective of that, if the vehicle is in the intersection and it's a violation of the statute, does that matter? Because the cases talk about whether or not that issue is of relevance. For example, whether you have a turn signal on, they seem to turn on the issue of whether or not the vehicle is stopped. So I just want to understand what your analysis is to say why it doesn't matter that your vehicle, whether or not your vehicle was in the intersection.
Because the truck had every opportunity to see Mr. Jorge's vehicle there and take evasive action. Right. It's not a situation where the two cars are moving. My car is stationary and has been stationary for over a minute.
So Mr. Greenspan, Mr. Greenspan, your argument is basically, I mean, you're there for a minute and a half to make that left turn. It should have been seen by whoever hit you in the rear's passenger side.
Precisely.
You're there, you're innocent, you're waiting for a minute and a half, as you should, for the light to turn.
Precisely. Now, Judge Acosta, you said you're very familiar with this area. Given this, the physical parameters of this intersection and the time of day, the fact that my client crossed the intersection and came within a foot and a half of clearing it, of being accommodated within that area, that's not unreasonable. All of us have been in that situation, whether we should go or not go. The fact that he got within a foot and a half of clearing the entire intersection clearly is in negligence.
Got you. It is heavily trafficked area. Vehicles going into Manhattan at 207. People making turns on south on the Deegan, north on the Deegan, trying to get into former Jimmy's Cafe there in the corner. It's a disaster. But I agree with you. You're there for a minute and a half. People should be able to see you.
Thank you.
So let me hear from the other side.
Do you want my rebuttal, Your Honor, or do you want to see if
No. Let me try to hear from the other respondent before you have your rebuttal.
No, not the plaintiff. The other.
Is he in?
Good afternoon. Can you hear me? Good afternoon.
I can hear you. Please identify yourself.
Thank you. I apologize. Donalo Cahoyne for the plaintiff respondent, Digna Acevedo de Jorge. I missed part of the argument because I called back in, so I apologize if I missed some of the questions the court put to the other attorneys.
Okay. So is there, go ahead and make your argument to the extent that you can.
Yes, Your Honor. What I heard you asking the appellant in particular was about whether the accident actually occurred. And what I would say to that is that he said 2 or 3 times that the driver stated that the accident never happened. That is not accurate. The driver stated that he did not think the accident happened. He has no recollection of the day itself, what happened, what didn't happen. And what we do know for certain is that he was in that area, did make that left turn. The transfer of paint from the truck to the car is consistent with the testimony of the plaintiff, who was seated in the back of the car.
when you say the driver, you mean the driver of the truck and what he said?
Yes, Your Honor. Yes,
Okay.
Your Honor. My apologies.
Counselor, this is Judge Singh. What precisely did your client, the wife, the passenger, testify to when she first saw the white and green truck bearing the name Driscoll Foods?
Her testimony was that she saw a truck coming in, the rear of the truck hitting the left rear of the car, that there was green and white, and that they followed that truck.
So in other words, your adversary is incorrect when he says that the first time the truck was observed was after they followed the truck. Is that correct?
It was the time of impact, Your Honor.
Okay.
That's when the observation was made.
when did the plaintiff, your client, or the driver of the car, which I think was her husband, when did they first identify the license plate of the truck? Because they followed the truck onto the Deegan, I think, and at some point said, "Up there's the truck." So when did they get the license plates? When did they actually identify the truck that way? Did she testify?
Yes, on the Deegan, Your Honor, I believe after coming off the ramp, and everything fits into place. As regards what we do know from Metropolitan is that the truck was driving, that it did make turns in that area on a regular basis. So what they did testify to, that what they did identify as the truck was consistent with what hit them.
But weren't there a lot of trucks in that? I mean, we just said there's, I mean, that's a very busy area and there's a lot of trucks, and maybe, you know, in getting on and following the truck, there might have been a mistake. Look, you might be right, but isn't that an issue of fact at this stage?
I don't believe so, Your Honor, because the truck driver does not have any recollection of what happened. He knows that he drives that on a regular basis. They saw the green and white truck hit them. They turned around and identified the truck, and we know that's the exact route that the truck does follow, that it drives, it makes a left there, it drives south in the Deegan. This is not a random truck that they picked up going down the Deegan that day. It all falls into line with what they say and their testimony.
And you say that it wasn't a random truck because Ms. Jorge actually saw the truck when it struck the rear of the vehicle.
Yes, at the time of impact, Your Honor.
Right. Okay. Okay. Thank you, counsel.
Thank you.
Thank you.
Your Honor.
Mr. Bonanno, let me hear you for 1 minute.
Okay, Your Honor, just to be clear, there seems to be some convergence of the facts. In other words, the detailed identification of my client's truck didn't happen until he was on the George Washington Bridge. Okay, the description of what struck them, okay, as they were facing forward, looking in the opposite direction, is generally a white truck and with some green. That was basically the description. I can't hear you, Your Honor.
Counselor, I'm sorry, I was on mute. But didn't the plaintiff also testify it was a white and green truck with the name Driscoll Foods on it?
Again, Your Honor, I do not believe the Driscoll Foods part was at the time of impact. I think that was later after they caught up with the truck. Now, again, I apologize if I'm misquoting the record, but my understanding was there was a general description, like a white, it was a truck, it then got on the Deegan. They had to go forward, make a U-turn, come back around, wait for the light to change, then get back on in midday in afternoon traffic on the major Deegan, heading towards the George Washington Bridge, then supposedly ID the truck among all the trucks.
Yeah, but by the way, I don't see that part where they had to go and then make a U-turn. I see that.
That's the testimony, Your Honor.
They waited.
I
thought that they waited till the light changed, then follow the truck, and that's the record at 221, 225, and 229.
They were heading in opposite directions on Fordham Road West, Your Honor, and they had to go to the next intersection, make a U-turn, come back to get on the ramp to go to the major Deegan in the same direction. They were intending to go opposite directions on the Deegan. So
right.
they actually had to come back around.
They were going to go north on the Deegan. Your truck was going south on the Deegan.
Right, so they had to turn around, not do what they wanted to do, come back the other way, wait for that light to then give them the go-ahead to get on the Deegan, catch up with this truck, and then ID it. So I guess what I'm saying is, and my client does remember the day, and he says he didn't do it. And there's a 395, it says, like I said, I didn't do it. And then the question is, do what? He said, hit that car. And he says also previous to that he remembers that day and that he gave that testimony. So again, it seems like I'm being told I don't have a good defense, but that doesn't mean there aren't issues of fact.
Okay. Thank you, Mr. Bonanno. Thank you, everyone.
Thank you.
King versus Marsh McKellen. Only the respondent is arguing for 3 minutes.
That's right, Your Honor. Good afternoon, Your Honors. I hope everyone is healthy and staying safe.
Thank you.
May it please the court, my name is Cliff Atlas from the law firm Jackson Lewis, arguing today on behalf of Marsh & McLennan Agency and Marsh & McLennan Companies. The trial court's decision denying the appellant's premature motion for partial summary judgment on his declaratory judgment claim should be affirmed because there are multiple issues of fact precluding summary judgment. Primary among these issues of fact, based on the way this appeal has been presented, is whether appellant was terminated from employment with cause or without cause.
Yeah, I don't think that there's any disagreement based on the case law in this department that poor job performance in fact constitutes cause. The question that I have, and it's unclear to me whether that's going to be addressed at the trial. The question is the employer's obligation to comply with the employee handbook in giving plaintiff notice about that alleged poor performance or misconduct or anything else that may constitute cause.
Well,
Want to address that?
Yes, Your Honor. Two points with that. First, there is a disputed issue of fact with respect to whether or not there was notice given, and that is set forth in the papers. There are competing affidavits, as Justice Ostrager noted. Appellant asserts at page 111 of the record that he was not provided with any warning. At page 147 of the record, the respondent asserts that it indeed addressed the poor performance with the plaintiff. But the other point of that is whether or not that actually matters. And it is respondent's position that it does not matter whether or not there was cause or was no cause. And the appellant here has taken a view of the law that a restrictive covenant can never be enforced against an employee who was terminated for cause. And
Counselor, this is Judge Singh, and it's an issue that we probably don't have to get into, but since you raised it, and it's an issue that is of concern, at least to me, why shouldn't we follow our cases like Buchanan, Colchines, and then there are also Second Department cases, which have taken a much broader view of this issue of what the Court of Appeals said, which I agree with you is distinguishable. But why shouldn't we follow our case law and the Second Department?
Well, because the case law, and I'm glad you asked me the question, Your Honor, the case law is inconsistent with what the Court of Appeals has said. If you go back to the Buchanan case, Buchanan, let me say this, neither Colchins nor Buchanan contains any analysis of the standards for enforcement of a non-compete in a forfeiture for competition context as distinct from a rule of reasonableness context. And what these decisions appear to have accepted as true, but without any analysis, is that New York law bars non-competes or restrictive covenants altogether where the employee was terminated without cause. And this is where these decisions are simply inconsistent.
Is there a case that squarely addresses that issue?
Well, the Buchanan case, the Buchanan decision cites one case, and that's Post against Merrill Lynch. The Court of Appeals in Post against Merrill Lynch was talking about a forfeiture for competition context. And that is what in New York is colloquially called the employee choice doctrine. The Morris against Schroeder decision of the Court of Appeals reaffirms this concept. And the concept is really this, that in a situation where an employee is given the choice between accepting a benefit and giving up his right to compete, or rejecting the benefit and retaining the right to compete, in that circumstance, the non-compete will be enforceable without regard to its reasonableness. In order for employee choice to apply, however, and the Morris decision of the Court of Appeals makes this clear, the employee needed to actually have a choice in the matter. And it's in that context, that narrow context, that the court said that if the employee's employment has been terminated without cause, then the employer does not get the benefit of the lowered standard of the employee choice doctrine.
Right, but that's because the Court of Appeals, even imposed, as we did in Colching, recognizes that there is a mutuality of obligations, which is destroyed when the employer terminates the relationship without cause, right? That's what Post says.
Well, it doesn't say that in quite that way, Your Honor. It says that it's dealing specifically with the forfeiture for competition context, and we've quoted the section of the Post against Merrill Lynch case in our brief, and we've quoted extensively from the Morris against Schroeder decision. These decisions make it clear that what they're talking about in that context with respect to whether or not the employee was terminated for cause or without cause is whether or not the covenant can be enforceable without regard to its reasonableness. If the employee was terminated without cause, it's not that the covenant isn't enforceable at all. Rather, it's that the covenant needs to be analyzed and scrutinized in accordance with the stricter standard that should be followed in any rule.
See, I thought that I was almost quoting Post verbatim. I mean, I think Post did discuss forfeiture of earned benefits, right? That's what that was about. He also discussed more broadly how the mutuality of obligation on which a restrictive covenant rests is Post language. It is destroyed, and again, destroy is Post language, where the employer, and I'm quoting them, terminates the employment relationship without cause. That's what Post says. I mean, I know that in coaching, we took a broad interpretation of what that mutuality of obligation is, but, you know, it's the First Department, right?
Well, I think it's important also here, Your Honor, that there is not a non-compete in the agreement at issue in my case. It's a...
I agree, and that deals with the reasonable. I got you. I got right. You. That's why I had some questions from your opponent, but he's not here. So,
what can I say?
And then how would you counsel or distinguish the Second Department cases, like for example, Grassi and Bourne, because those cases do take also an expansive view of Post, no?
Yeah, I think that those cases are incorrect as well, Your Honor.
Okay. Thank you, Mr. Atlas. Much appreciated.
Thank you for your time, and thank you for hearing me today.
People versus Vega.
Good afternoon, Your Honors. May it please the court, David Bernstein, Office of the Appellate Defender, on behalf of Mr. Vega. The fact that Mr. Vega was tried for 4 unrelated burglaries in a single proceeding created a substantial risk that the jury might convict him of 1 or more of those burglaries, not on the evidence presented, but for propensity reasons. In fact, the jury was told that if it believed Mr. Vega had committed 2 or more of the offenses in a distinctive pattern, it could use that as proof in considering the remaining burglaries. So under these circumstances, Mr. Vega's Rikers Island statements should not have been admitted against him at trial. They only compounded the risk that the jury would convict solely because it believed that he was a lifelong burglar.
Was this issue preserved? I'm not clear that it was preserved. Wasn't the argument more nuanced at trial?
Well, actually, for the moment, I'm kind of making the argument that counsel did make. Counsel made some arguments in objecting to these calls coming in. Basically, he said that these calls would be more prejudicial than probative. Exactly. And that's really what I'm focusing on today. I think that the statements should not have been admitted under the Molyneux reasons exception for the reasons set forth in my brief. But I think today the important thing that I just want to call your attention to is why it was so prejudicial. They basically changed this from a trial about 4 specific acts into one about Mr. Vega's extensive criminal history. First, the jury learned that Mr. Vega was charged with 4 unrelated burglaries. Then it heard 4 Rikers calls suggesting that he had in fact committed many more. And one of those undisputedly referred to a specific residential burglary 6 years earlier. I think that even though that should not have come in under the Molyneux exceptions for the reasons I've stated in my brief, even if it fell within one of those exceptions, it was far more prejudicial than probative. But even more prejudicial than that statement was another portion in the same call where Mr. Vega talked about his MO for burglarizing closed stores.
Yeah, but there were portions of that tape that were excluded, right? I mean, the court just didn't allow it wholesale.
That's true. I mean, there were even more prejudicial portions which were kept out, but I think that Mr. Vega's use of a specific phrase, MO, that has a criminal connotation was extremely prejudicial and ramped up the risk that this was going to be used as propensity evidence. And given that, plus the specific reference to the residential burglary, the other calls in that context just layered on top of one another, and on top of the fact that there were 4 other burglaries that were totally unrelated to each other that were being tried together, and the prejudice just kept compounded. And so under these circumstances, where the trial became more about Mr. Vega's history as a serial burglar than about his commission of the specific burglaries charged here, he was denied his right to a fair trial. I'd like to just very briefly turn to the sentencing argument if your honors don't have any questions on the prior bad acts.
Go ahead.
Okay, thank you. Before trial, Justice Klott offered Mr. Vega an 8-year sentence in exchange for a guilty plea. Now, we can talk about why he refused to accept that, but that's not really the point here. The point is that an experienced jurist familiar with the facts recognized that Mr. Vega is not a violent, irredeemable criminal. He's an addict who has experienced all kinds of abuse throughout his life. And 8 years was a reasonable sentence given that background and the nonviolent offenses here. Now, Mr. Vega made an ill-conceived...
You would have the 8 years, right, if you run the attempted burglary count concurrently with a burglary and attempted burglary in the second degree and the trespass. Correct?
If you ran them all concurrently, I believe there's still a 10-year sentence on the top count, but there would be a 10-year aggregate. That's correct, Your Honor.
Okay. I thought it would go down to 8. I didn't do the math, but
I mean, 8 would be great. I think that, I think it's appropriate here, given what, Justice Klott's evaluation of the letters, Mr. Vega's expressions of remorse and letters to the court, and his obvious, drug addiction problem. I think that was an appropriate sentence. I understand that once a defendant goes to trial, that may not always be considered a reasonable substitute, but certainly 10 years running all of the sentences concurrent would be more reasonable under these circumstances. Mr. Vega's expressions of remorse were significant here before trial, in letters to the court, when he asked Justice Mandelbaum to let him plead guilty, and then after trial. And so for those reasons, we would ask.
I think that, we'll see whether the people agree, but it's convincing that there was contrition here.
Thank you very much, Your Honor.
Let me hear from the people.
Good afternoon, Your Honor. Court Samuel Goldfein on behalf of the people. I guess I'd like to start with the recorded statements, Your Honor. To begin with, that it's pretty clear from this record that defendant was not convicted on any basis of propensity. I mean, the jury clearly by their verdict, they evaluated separately, they reached separate, and that's really proven by the fact that they acquitted.
Part of what they argue is that some of the omissions that were introduced were overkill, and in fact they were more prejudicial than probative, because once the jury heard that about other burglaries, it's over.
Well, Your Honor, to begin, I would say that the jury only was aware of one uncharged burglary at that time, which is the one that he mentioned. The other ones, I think it's fair that they were ambiguous. I think it's admitted as admissions of the instant crime, not of uncharged burglaries. But the jury did not convict on propensity. They evaluated each incident separately. Concluded that he was not guilty of some and guilty of the other. So this notion that they were just convicting him because is factually untrue on this record. Now, in those statements, not only was that not prejudicial to the defense, it was actually beneficial to the defense. Defense counsel took that statement and he ran with it, and he convinced the jury when this defendant entered unlawfully into these premises that he actually for a non-criminal purpose. He was just looking for a place to sleep. And by the jury accepted that argument, and they acquitted him of second-degree burglary. Instead of facing a 7 to 15-year sentence on a violent felony offense, he was convicted of trespass. 1 year determined.
I guess you disagree with the ineffective assistance claim. If we had a sufficient record to hear that claim, can you address yourself to the sentence, Mr. Goldfein?
Absolutely, Your Honor. So on the sentence, I agree with Your Honor's assessment that the sentence is a high sentence, but I think that's for two reasons. One is that defendant is a violent predicate felony offender, and these are the sentencing ranges. I mean, with the exception of burglary in the second degree, Your Honor, defendant gets on every count. He gets the minimum on third-degree burglary. He gets the minimum on attempted second-degree burglary. And on the second-degree burglary, he gets 10 years from 7 to 15, so 3 above the minimum, 5 below the maximum.
Counselor, how do we assess the apparent drug addiction issues that the defendant has had for many, many years in assessing the excessiveness of the sentence? Does that have some bearing?
Your Honor, I believe that it does have some bearing. I'm not sure what the exact. I think Justice Mandelbaum went with giving him near minimum.
Say that again, Mr. Goldfein. You broke down.
Oh, I'm sorry, Your Honors. I'm not sure where you lost.
You didn't break down.
You're going in and out.
Yeah, I'm sorry about that. I would just say that I think Justice Mandelbaum accounted for defendant's drug addiction when giving him minimum or near minimum sentences on each count. The fact that the sentences, I think, as Justice Mandelbaum says,
he didn't run them concurrently, did he?
No, he ran them consecutively, Your Honor, and I think that is the situation. Defendant committed 4 separate crimes with separate victims on separate dates with separate investigations.
Yeah, yeah.
But I take Your Honor's point. 17 to 19 years is a long sentence, but I think that's a product of the fact that it's multiple crimes and his criminal history, quite frankly.
So you don't think his drug addiction and clear contrition? I mean, it was pretty clear from his letters and the record that, he is contrite, he is remorseful. Do we do anything with that? I mean, you had originally offered 8 years, right?
That is correct, Your Honor. That was, of course, before the whole expensive trial. All the witnesses needed to be called. And this was a pretty massive investigation. And
so he should be penalized for exercising his right to a trial.
Absolutely not, Your Honor. That's absolutely not what I'm saying. There's a recognition that sentences after trial. And I would say that this crime occurred weeks after he was in prison on another burglary. He was still on parole. I mean, drug addiction is definitely part of the problem, but despite involuntary drug treatment, he doesn't go to the programs. He doesn't participate. So I'm not sure what the solution is, Your Honor, but.
Okay.
I ask that you.
Thank you
very much.
Thank you, Mr. Goldfein. You get 1 minute, Mr. Bernstein.
Oh, I thought I had 2. I'll try to make it as quick as I can.
I'm sorry. You're right. You have to.
I'll try not to use all of them. Just very quickly, my adversary suggests that the jury did not convict on propensity grounds here, although I don't know how we can possibly know that. I mean, the jury heard here about 4 totally factually unrelated burglaries, then that were charged in this case, then a specific one 6 years earlier, then a statement in which Mr. Vega describes how his MO is to repeatedly go into stores and take money from registers. And then there are 3 more statements on top of those in which he says, I'm not the only person who does burglaries. I didn't take anything from you. I was out there night after night after night. So I think it's, very likely that there were propensity things here. And I think as proof of that, I think we can look at one thing. The jury's acquittal on the burglary of the basement storage room, but conviction of trespass, in that offense, there was no photo or video evidence. There was only a palm print outside of the building. And so one might think that given that was only outside and he was not convicted of attempted trespass and he was not seen inside the basement storage room, that the jury in fact did convict him of that trespass rather than acquit altogether because it thought he was a burglar. So I think there's support here for that in the record and in what the jury did. And just lastly, with regard to the sentence, look, addiction is obviously a very significant part of our explanation here and why we believe Mr. Vega is entitled to some of this. But there's also the fact that he in reports and letters, he has talked about trauma throughout his entire life, emotional abuse, sexual abuse, all kinds of things. And on top of that, and aside from his expressions of contrition, there is the fact that he has shown capacity to work in various jobs when he has been out in the past, that he has completed some community college courses. And so I think that this sentence is much more in alignment with what this court has deemed appropriate in homicides and rapes and shootings, not in property offenses, essentially property offenses like this. So we ask that you reverse or modify the sentence. Thank you very much.
Thank you, Mr. Bernstein. Thank you, Mr. Goldfein. Nash versus Port Authority.
Good afternoon, Your Honor. Can you hear me?
We can hear you.
Great. Okay, so the threshold issue on this appeal, I think the one that needs to be considered first, is whether or not the unilateral payment by the Port Authority of the entire judgment amount into a bank account in which plaintiff or her attorneys had access was, quote unquote, a settlement such that it shifted liability for the marshal's poundage fee from the judgment debtor, which normally would have it, to the judgment creditor. Now, the one document of the record that I would really ask Your Honors to look at is at pages 119 through 120 of the record. In connection with the oral argument on plaintiff's motion for the entry of the judgment. Now, the motion was made, I think, in May of 2009. It was heard. The motion was heard oral argument was heard on August 20th. On August 18th, in connection with that motion, plaintiff submitted an affidavit saying, if a judgment is entered, this is how I want you to pay it to me. And she put all the information about the bank accounts so that a wire could be made. And that's exactly what happened after much, much more litigation. 5, 6, 7 years later, the Port Authority, without any cooperation whatsoever from the plaintiff, simply wired that judgment amount. So now the first question.
How did that occur? What resulted in the Port Authority wiring the money? What cost?
Obviously, as Mr. Mangone said in one of his emails, the service of executions got their attention. They were obligated to pay that money long before those executions were served. That's what said, okay, the game is finally up. Now we can't avoid it anymore. But they didn't ask they asked Mr. Mangone to help, but he refused. He said, I'm not giving you anything. I'm not giving you the time of day. The other thing to bear in mind, Your Honors, and this I think is critically important, the executions that had been served included the full amount of the marshal's poundage fee. That settlement, or if you call it a settlement, I call it that payment, I should say, in no way prevented the marshal from continuing to enforce the execution to the full extent of his poundage fee. It had nothing to do with it. Those executions were still in force. The only reason they couldn't be acted upon was because the trial court had enjoined the plaintiff and her counsel and the marshal from enforcing the executions. But
yeah,
I would ask the court.
Let me ask you, can I ask you a more basic question?
Sure.
Because, I mean, the Port Authority went ahead and paid. I know that we litigated in a prior case in which I was part of the issue of waiver of sovereign immunity.
Correct.
So the question is whether sovereign immunity to be sued in tort, as in this type of tort action, is the same or extends to the payment of poundage for a marshal.
Okay, well, I'm glad you asked that question, because the answer, I think, of course, is no. This court's decision, of course, which says that the Port Authority is to be treated just as any other commercial landlord, was reversed by the Court of Appeals, but not entirely reversed. It was reversed with respect to the issue of whether the Port Authority can be held liable in tort when it's acting as a governmental agency. The question of whether, as a judgment debtor, it pays poundage has nothing to do with its quasi-governmental functions.
And so you don't think that holding the Port Authority responsible for poundage a broader interpretation of the waiver of sovereign immunity issue?
No, I don't think it. To the contrary, I think the Port Authority is arguing that they can't be held liable for poundage because they have sovereign immunity from it. This court said, no, you don't. The Court of Appeals agreed, no, you don't.
But is that an accurate statement, Counselor? Is that accurate? It wasn't in the context of a tort and not poundage is what Judge Acosta and the other judges of the panel were making that decision?
I'm sorry, I'm not following the question, Your Honor.
I'm questioning the accuracy of your statement in terms of what we did. Why would the Port Authority be liable, would have given up sovereign immunity for poundage?
Well, this court and the Court of Appeals said the Port Authority does not have sovereign immunity against typical tort claims.
That's right, for tortious conduct.
And I don't understand why that would somehow mean that when they've been convicted of tortious conduct and they're paying the judgment, that somehow they have sovereign immunity from some of the costs associated with that judgment. Poundage is just a cost of judgment. If they're liable for the judgment,
no, but poundage is totally statutory, right? You don't think that makes it wholly statutory? Do you think that makes a difference?
No, I don't, for the reasons I said in my brief. But truthfully, Your Honor, I think that's really far down the chain of the argument, because the first question is whether or not the burden even shifted from the court, whether or not the Port Authority is ultimately can be held liable for it. If the plaintiff can't be held liable for it, the marshal can't seek it from the plaintiff. If he
let's assume for the moment, let's assume for the moment that the Port Authority of New York consented to poundage, basically. Do we require New Jersey to do the same?
No, Your Honor. I covered that in my brief. But in all candor, Your Honor, that argument, you only get to that argument after three other arguments that have to be addressed first. all right? Because the first question is the plaintiff liable for the poundage? It has nothing to do with whether or not the marshal can successfully seek them from the Port Authority.
You don't think the plaintiffs, you don't think that the settlement, I mean, I know there's a question as to whether the payment of the judgment is a settlement, but the question is whether, whatever we characterize it, does it shift responsibility for poundage to the plaintiff?
Correct. That's the question. That's the question I'm trying to argue, Your Honor. And I'd like to refer the court to a case. It's a trial court case, but this court relied on it in Cabrera v. Hearst. And it's called Greenfield versus Tripp. It's cited at page 8 of my reply brief. And it explains what it is about a settlement that justifies, as a matter of equity, because the issue of who's responsible for poundage, as many courts have held, is an equitable issue. And it says here, the plaintiff agreed to take payment directly from the debtor. That is an affirmative act interfering with the collection by the sheriff. That's the point. There has to be an agreement, which there was not here. There was no agreement.
Can you, Counselor, address the June 11th, the June 2011 agreement that was drafted by Mr. Mangione with respect to poundage?
Well, that issue is the second important issue, and that if you don't agree with me that this was not a settlement, and that even if it was a settlement in equity, it wasn't the kind of settlement where the plaintiff judgment creditor somehow affirmatively interfered with the marshal's collection efforts, because that's what you have to decide even to shift the burden at all. Then the next question becomes, did the marshal waive his right to collect the fee from the plaintiff in those circumstances? And the answer to that question, I think, is also yes, because the marshal's letter very specifically said, if the executions are vacated, then even if I can't get it from the Port Authority, I'm still not going to.
So let me stop you there. In this case, were the executions vacated, set aside, or discharged?
The answer to that question is the court did not use the word vacate, but the actual fact is that's what the court did.
But didn't the court essentially deny the Port Authority's motion as moot? So it never really reached a threshold issue that the executions are vacated, set aside, or discharged.
That's the word that it used. The court, however, the substance of its opinion says executions cannot properly be served on the Port Authority. Until it issued that decision, the settlement, as I said before, those executions were still outstanding. The stakeholders were still restrained from paying those monies to anyone else. They still had to hold them to the full extent of the marshal's poundage fee. It was only when the court issued a decision
but let's stop that. But what about, this is, I guess I'm having an issue with that, because the marshal serves the various restraining notices. The next day payment is made. Doesn't that suggest that the executions were actually complied with?
No, because the executions also included the marshal's poundage fee, and the Port Authority did not pay that.
But the executions were never vacated.
Excuse me?
Right? The executions, the one view of the evidence is that the marshal serves the executions, the monies are paid, Port Authority comes into court, the court denies the motion. So isn't there a view of the evidence that the executions were not vacated, set aside, or discharged?
No, only if you exalt form over substance, Judge. Because
okay, fair enough.
Let me just play this out, because as I say, those executions remain in force while that motion was pending. The court then issues a decision that says, as a matter of law, the marshal could not properly have served executions on the Port Authority. At that point, if the marshal went ahead and tried to enforce those executions to the extent of his poundage fees, he would have been in contempt of court. No ifs, ands, or buts. He couldn't have done it. And the fact that the court did not use
so then how did the monies get from the Port Authority to the bank account after service of the restraining notices?
Wire transfer.
Right. So did not the Port Authority comply with the executions?
No. Because the executions included an additional. They complied with part of the execution, but not all of it.
Okay.
Not all of it.
Thank you, counsel. Let me hear from the respondents.
Thank you, Your Honors. David Crom on behalf of defendant respondent, the Port Authority of New York and New Jersey, if it may please the court. Your Honors, the lower court in this case correctly held that the Port Authority that the marshal's poundage fees were could not be assessed against the Port Authority for 3 separate, distinct and unique reasons. One of those reasons, which you discussed with the appellant's counsel before, was the fact that the Port Authority had not waived sovereign immunity with respect to the poundage fees. But that's not the only reason. As the lower court correctly held, the Port Authority is a state agency under CPLR section 5207. As the Court of Appeals has expressly held, quote, the Port Authority is and of necessity has to be a state agency. By that, the Port Authority is, you cannot, pursuant to CPLR 5207, none of the procedures.
Counselor, what caused the Port Authority to wire the funds to satisfy the judgment? What was the precipitating cause of that?
Well, frankly, I mean, I do know that the Port Authority was made aware of attempts by the Marshal's Office to impose a lien or levy upon the agency that was that the agency has correctly believed was improper.
Was that the reason why the judgment was satisfied?
I honestly cannot answer that question. I mean, I think that when you look at it, they made aware. The agency was made aware of it, and then very shortly thereafter made.
Wasn't it like the next day the wire transfer was made from the Port Authority to the accounts of the plaintiff, and I guess separately to the account of our lawyer, like the day after the marshal executed, served that. So didn't that happen like virtually the next day, even though it may have been years that you may have had to pay it? On that day, the money went out.
It was very shortly thereafter.
Yeah, very short.
Okay, and then the other money. I'm sorry, go ahead.
No. That money that was wired on April 7th of 2016 only included the judgment amount minus the poundage.
Correct.
Okay.
So the question I have is, Supreme Court denies your motion to vacate the execution. It goes through the analysis you're making. Why do you think Supreme Court, and maybe this is an unfair question, after going through that analysis, denied the motion as moot?
In my opinion, I believe it was because that the execution of levies are improper. Execution of levies on the Port Authority are improper in and of themselves.
Or that the levies were satisfied, that the restraining notices were met and satisfied. So there's really nothing for the court to decide other than saying that you weren't responsible. Correct?
I mean, the court did acknowledge that the amount of the judgment was paid and that the Port Authority was not responsible.
So wouldn't that moot out the application at that point?
It could moot out the Port Authority's application at that point, under the assumption that the Port Authority is not responsible and the amounts were paid. Correct.
Thank you.
Questions? Okay, let me hear from the marshal.
Good afternoon, Your Honors. May it please the court. My name is Alex Leipson. I'm for the marshal, the non-party respondent in this case. I think it's important to look at this case from 10,000 feet, from a bird's eye view. It seems that everybody's in agreement that the marshal performed a service that bestowed an enormous benefit on the appellant here. In fact, the marshal served executions which caused the Port Authority, as the justices just stated, to make a payment, a wire, that settled a judgment of over $11 million.
But is that settling a judgment or is that satisfying the judgment?
It's settling a judgment, and I think it's important. This idea that the marshal's fee was excluded from the judgment, that is the settlement here. So it's not, as counsel for the appellant indicated, a unilateral action. The settlement here was the Port Authority sees the executions, which include the poundage, make a wire, the Port Authority and the appellant's counsel talk on the phone. They have conversations about money being, the judgment being satisfied. The Port Authority then wires money to satisfy the judgment to the appellant. The appellant receives it, confirms receipt, and then sends a satisfaction of judgment to the Port Authority, acknowledging that that the judgment has been paid. It's a weird conversation to have, but the appellant's counsel could have at that point called the Port Authority counsel and said, "I can't accept this judgment. You're saddling me with the poundage fees, which is several $100,000, by creating essentially a settlement here." The appellant's counsel could have gone back to court and said, "What do I do here? Am I obligated to send satisfactions of judgments now? Because it appears to me that the judgment has been settled." He didn't do any of that. So what he did was effectively participate in the settlement of the judgment and allow Marshal Ocasio to fend for himself in collecting his own fee. And that in of itself is affirmative interference. But I do think that that's a settlement of the judgment, which shifted the burden from one side to the other.
So, Mr. Leibson, what do you say in terms of the letter from Mr. Mangione to your client? And it was on 178 to 188 of the record. I don't know if they call that the stipulation or agreement. And there's a portion at the bottom where Mr. Locascio signed it, and he said that he would waive and not seek from Ms. Nash or Mr. Mangione or any of their heirs any part of the poundage fees that he might be entitled to in the event I serve executions in the matter and the executions are waived, set aside, or discharged.
Justice Kapnick, what I say to that is that the executions were not vacated, set aside, or discharged. There's no dispute that there was no order, and there was some colloquy between Justice Singh and the appellant's counsel about this. There's no order that vacated, set aside, or discharged. What the appellant's counsel wants to do is act in hypotheticals here, but we don't even need to get to the hypotheticals, because I think it was Justice Acosta who pointed out the executions were effective. They did what they had to do. If there were, the executions were sent in August or in April, on April 5th. On April 6th or on April 7th, the judgment was paid. Yeah, how could the executions have been vacated, set aside, or discharged if they were effective, if they had done their job? If they were vacated, set aside, or discharged, then the Port Authority wouldn't have paid a day after the executions were rendered. That's why the lower court held that the Port Authority's motion to vacate the executions was moot, because it had already been effective. And it's really just engaging in hypotheticals that we don't need to reach here to argue one way or another. So it's not arguing form over substance, as appellant's counsel indicated. It's operating in reality, really.
And this isn't the reality, Mr. Leibson, that a waiver of sovereign immunity for suits standing in tort is a totally different issue than, or certainly a broader issue than obligating a state agency to pay poundage when it is otherwise exempted from paying.
Well, so to answer your question, I mean, to be clear, the marshal doesn't care which entity pays him. He just cares.
No, you want to be paid.
So the question of sovereign immunity, I mean, it was litigated 3 times in the lower court, and the lower court upheld its own holding that there was sovereign immunity on the case of the Port Authority. And in that case, there's only one entity left to make the payment to the marshal. So this is another issue altogether. But when we're talking about whether there's a waiver, the cases.
The referee report is very clear that you didn't waive your right to collect the poundage. And
That's
I think
right.
the court accepted it. So the question is who pays it, right?
That's right, Your Honor.
Okay. Okay. Let me hear back from.
Yeah, good. Mr. Leibson referred to conversations between Mr. Mangone and the Port Authority's lawyer after the service of the executions. The conversations, I'm obviously not quoting, but the conversations in essence were, "Hey Lou, help me get rid of these executions." Lou's answer, "No." "Hey Lou, tell me how much I need to pay to get rid of this." The answer, "No." That was the conversation. There was nothing bilateral here that even remotely amounts to a suggestion that somehow they were going to waive some sort of right that they otherwise would have had there not been payment. And then you get back to the key point. After the levies were served, they were not satisfied. The judgment was paid. The levies were for the amount of the judgment plus $600,000. That part of it was never satisfied. And then, as Mr. Crom said, and I think I'm trying to quote it here, he said, the trial court, after, a year and a half later, after the stakeholders were holding that money to satisfy executions, should they in the end be enforced once the TRO and the preliminary injunction were lifted? As Mr. Crom said, the court said the executions served by the marshal could not be enforced against the Port Authority. That is what freed the stakeholders from any obligation to hold that $600,000 poundage fee. Now, yes, the word was not vacated, was not used. The word vacated is defined in Black's Law Dictionary as annulled, set aside, canceled, rescinded. When the judge said those executions can't be enforced, period, that's what happened. Those executions, which still were outstanding and which still would have required the stakeholders to pay the marshal his poundage fee, all of a sudden, as a result of that decision, no longer were of any force and effect. They were annulled, they were rescinded, they were set aside, they were canceled, i.e. they were vacated. The judge below, for whatever reason, and I can suspect that he probably figured, because in a way, Mrs. Nash was lucky because as a result of the Port Authority's failure to take some procedural steps, she's the only plaintiff who actually got money.
Right.
And I think what really happened here, and I hate to say it, is the judge looked at it and said, hey, she got all this money, shouldn't she also pay the marshal's poundage fee, whether or not legally that's what should happen? And
Counsel, who drafted the June 2011 agreement or the letter, whatever it is? Mr.
Mangone
Mangione?
drafted it, and he drafted it poorly. No question.
Drafted it poorly? Is that what you said?
Yeah, he drafted
Would you
it poorly.
agree
There
that
are
to the extent,
typos. There are typos.
forget the typos, in terms of what this language means, executions are vacated, set aside, or discharged, shouldn't he be bound by those by those words?
Yes, and that is what happened. Discharge is another funny word, Judge, because again, that's a much more generic word than vacate. And if you look at Black's Law Dictionary of the definition of discharge, it's exactly what happened. But I don't have it in front of me, but I did quote it in my brief. Essentially, discharge is a generic term for whatever it was before, whatever obligations were imposed by that order before are no longer imposed. And that's what happened.
Thank you,
when
counsel.
the judge said, you're welcome. Judge. Thank you very much for hearing me
Thank
out,
you.
Judge.
Thank you all.
Thank you, Your Honors.
Lopez versus MTA.
Good afternoon, Your Honor. Jonathan Schaub for the appellants. May it please the court. The Supreme Court's order should be reversed in this case for the simple reason that the defendant's motion for summary judgment was timely under the controlling preliminary conference order. As plaintiff has not identified any authority.
Counsel, was Judge Getz told that the PC order that had been written in so order by Justice Wright still in operation?
Your Honor, I'm not sure the answer to that question. I don't believe that's in the record. We were brought on as appellate counsel after the fact, but it's consistent with this court's precedent that when there's a preliminary conference order or any type of order, it controls over a part rule. So in this case, the decision, the underlying court relied on a case that involved a conflict between two competing part rules. Here we have the order, and there was never a subsequent order changing the time from which summary judgment was due after note of issue. So plaintiff hasn't identified any authority to the contrary, so I'd like to jump to the merits of the dispute and the merits of the motion. And it's pretty clear on this record that the accident never happened. All of the objective evidence shows this. Several weeks after the date of the alleged accident, plaintiff sought treatment and care from two providers. The first was St. Joseph's Hospital.
Mr. Schaub, isn't it true that that the plaintiff testified that he was afraid to report the injury, even he says he was told, don't even tell your doctor that you were injured on the job, because he really needed the job, so he was kind of afraid to say what happened? Isn't that part of what the testimony is here?
So the testimony is he was told to say, don't, first of all, the boss who allegedly said that categorically denies that testimony, but I take your point on that. The larger point is he was told, don't say you were injured on the job site. That didn't mean lie about, or not lie, misstate and mischaracterize where you were hurt. In two separate cases, or to two separate providers, he denied suffering a fall, he denied suffering an acute injury, and in both instances, he specifically claimed that this pain began before the date of the alleged accident here. So these are his own pre-litigation statements that should be accorded greater weight than his subsequent deposition post-litigation testimony. And
so in other words, counselor, you're asking us to weigh the testimony here, right? Is that our function sitting here as appellate court to weigh the testimony?
Justice Singh, I think in the earlier case, the Legacy Yards case, you said when it's manifestly untrue that this court, and there's legion of authority.
That is
Here in this case, the testimony is manifestly untrue. We have his pre-litigation statements to multiple providers or multiple treaters in which he denied suffering any fall or any type of acute injury. And in both instances, first at the hospital, he said the pain in his shoulder began 4 days before the date of the alleged accident. And to his orthopedic surgeon, he said the pain began 2 months before the accident. So this is a case where plaintiff's own words have undone his claim, and the subsequent post-litigation, after he's retained counsel for his deposition, his statements in his deposition and those of his coworkers are tailored testimony, and they're so rife with holes and inconsistencies that they shouldn't be afforded any weight whatsoever. So to take two examples, plaintiff claims that he was injured because he tripped on wood that was on this beam. First, he said the carpenters were cutting the wood on the beam. Then he said they were throwing the wood up onto the beam. After that, his own witness, Mr. Alcantara, testified there was absolutely no carpenters in the area at the time of the accident, and there was no debris on the beam. So that's his own witness that undermines his claim. Then the gentleman who testified couldn't even put forth a consistent statement as to where they were at the time of the accident. Plaintiff claimed that Mr. Gonzalez was standing behind him, and Mr. Alcantara was behind Mr. Gonzalez. Mr. Alcantara said, no, I was standing behind plaintiff, and Mr. Gonzalez inexplicably said I was standing in front of plaintiff.
That sounds like a lot of issues to be weighed, no?
They're not, because it's, again, consistent with this court's testimony or this court's rule that when it's manifestly untrue, and we just have to go back to plaintiff's statements to his providers, this accident didn't happen. And now let's just consider what it is that he's claiming was the mechanism of injury. The plaintiff is claiming he was walking on an 18-inch wide beam carrying a 70-pound piece of rebar that was 17 and a half feet long. That's the athleticism required to accomplish that feat without falling is remarkable. It's simply not believable. And when that's layered,
employees are usually asked to do a lot of that maneuvering, but I'll let you respond to that in your rebuttal.
And then briefly, Your Honor, briefly, Your Honor, to the extent that there's a question of fact as to whether this accident happened, it still wouldn't allege or still plead a labor law 240 claim. He was plainly the sole proximate cause of the accident. No one directed him up onto this beam. In fact, they were told, the workers were told on this job site, if you go on the beam, you will be removed from the job site. So his own decision to walk on this beam was problematic, nor did he face even a foreseeable gravity-related risk.
Thank you, Mr. Shaw. Let me hear from your opponent. You
You're
are muted,
muted,
Moyne.
Miss Moyne. You're muted.
Okay, I'm sorry. My name is Cheryl Eisberg Moyne. I'd like to get back to the threshold question here that the defendants have not established that Justice Getz abused his broad discretion in enforcing his part's published rules. The defendants were never confused here about the identity of the justice to whom
But
they
Counselor,
were
isn't there
motion.
case law that's inconsistent with what you're saying? Our decisions
No,
really.
it's not. This is a case where on their own motion papers and affirmation on page 15 and 17 of the record, they typed in Justice Getz. So you're obliged to be aware of the court rules, which were a matter of public record, and it was in
So
boldface.
what do you do with standing orders like the one from Justice Wright, which let me ask the question.
I'm glad you're asking me that question because rules change. Today, I am sitting with 66 pages of the United Court System's new rules affecting summary judgment motions. I have to familiarize myself with the new rules that in the court before whom I am standing. I can't say now that when I started the case, we didn't have to have this in a motion for summary judgment. Why publish court rules in boldface? The court rules of Justice Getz, before whom they were.
Counsel, it is also true that if I'm litigating a case and I enter into a preliminary conference order that is so ordered by the judge, and that preliminary conference order says I have 90 days to file dispositive motions, and then the case gets transferred to another judge, and that order is not vacated at all, it's still standing, and there's no statement from the judge saying that that order is not valid, that I can rely on a court order.
Right. Well, we cited two cases in this court, Applegate and also Giudice case. And in the Appleyard case, which is a recent 2019 case, the case was assigned to a judge just 4 days before the 60-day period, and the motion was deemed untimely. Here, the defendants, if there was any ambiguity, could have sought an extension, but here they argued that they were unfamiliar with the published rules. That was the same argument made in the Appleyard case, and Appleyard is good law. It's been cited all the time. It was cited on January 7th in this court.
So that's not what's being argued here. What's being argued here, and the issue, the way that I see it, is whether, despite the shortening of the time period by Justice Getz's rules, whether that supersedes a preliminary conference order that has not been vacated, that is still standing and in full operation.
But in this court, there were published court rules, and in the Giudice v. Green case, there was some ambiguity. There were different statements in a PC order and a compliance order. So, this is the kind of thing, if the defendants had a question as to whether Judge Getz was going to be applying his own court rules, or whether an order which probably had many other things in it from 2 years ago was going to take precedence. This was something that should have been brought to the court's attention. Judge Getz is the captain of a ship in his courthouse, and he puts in boldface that the rules here are 60 days. And attorneys have to be aware of the parts they are in now. We have to be aware of the new rules coming down.
Counselor, I'm sorry, respectfully, can you address some of the merits of the arguments? I'm more interested in that.
Okay. So on the merits of the case, this is a case that falls directly within the ambit of Labor Law 240-241-6. This is a case where the defendant on its motion did not submit any expert proof here on custom and on usage, on statute.
Well, let's start with sort of the threshold issue here, and that's what your adversary says essentially, that your client's statements are patently unbelievable with respect to the occurrence of the accident, relying in part
on what he said to his treating physician a few days after the accident.
We have to remember that this was somebody who was a Spanish speaker. He only had a third grade education. The defendant here really makes an unsupported attack on the plaintiff's credibility, that this accident never occurred. Credibility is a question reserved for the trier of fact, particularly here where there are two co-workers who saw him fall and his supervisor believed him as well. The plaintiff here was in no position as a worker on a construction site to demand and search out a safer route, or this is the reality of a construction site. You do what you're told. You don't dictate to your boss how you get the rebar to the installation area. You do what you have to do to get there. And in fact, based on this record, we urge the court to grant summary judgment to the plaintiff as he fell from an elevated beam here.
Basically, you're asking us to search the record, right? Because you didn't file.
No, we filed a cross motion.
No,
also,
you didn't file. The rules of this court are that you need to file a cross appeal in order to get relief, right? Affirmative relief.
You can search the record in the Court of Appeals in the Glenford Morris case. They searched the record and granted our firm Labor Law 241-6 summary judgment, and that went up to the Court of Appeals. So absolutely, this court can search the record and grant the plaintiff summary judgment here. The entire.
Thank you, counsel. Your time has run out.
Okay, thank you, Your Honor.
Counsel, you get 2 minutes rebuttal.
Thank you, Justice Acosta. I know it's been a long day, so I'll try to be brief. Just to your point quickly about the conflict between part rules and preliminary orders, this court's already decided this issue in Encore 1 in the Winfield case, which we cited. Justice Singh, I want to return briefly to what we were talking about the manifest untruth of the statements. This court's decision in Price, this court said that the plaintiff's testimony was manifestly untrue.
Well, but in this case, is your adversary correct that this is not an unwitnessed fall, that there was somebody there?
So there were two witnesses there, but again,
so then essentially what you're asking us to do is ignore the testimony of all the witnesses as tailored. The testimony of the plaintiff is manifestly untrue, correct?
Yes, Your Honor, but there's precedent for that, and that's the Price decision. In the Price decision that this court decided, the court found that the plaintiff's testimony was manifestly untrue, notwithstanding the fact that the plaintiff's mother had put in an affidavit supporting his version of events. So it's not unheard of for this court.
Well, I'm not sure what the mother saw or didn't see, but in this case, they're witnesses to the alleged accident, right?
But the mother in that case was a witness to a conversation where she put in an affidavit saying that it happened, supporting the plaintiff's claim in that case. So when there was two competing pieces of testimony, there was support for the plaintiff's account.
Well, testimony from the mom from the mother is different than a coworker, right? One is interested, the other one may not be, as a matter of law, right?
Correct, but the co-workers here don't actually even support plaintiff's claim. Plaintiff said he tripped on a piece of wood. Plaintiff's co-worker, Mr. Alcantara, said there were no carpenters around the beam at the time of the accident, and there was no debris on the accident. The other worker, Mr. Gonzalez, he was supposed to be, according to plaintiff, he was standing behind him. Then Mr. Gonzalez says I was standing in front of him. This testimony is just manifesting untrue.
Wasn't there testimony even from the defendant? Not the defendant, but there was I guess a safety organization, WSP Parsons Brinkerhoff, and didn't they were hired by New York City Transit as a consultant, and didn't someone report that there was debris in the area, at least that she had seen it the day before? So wasn't there some issue about the debris also?
So there are two responses to that. First is plaintiff testified that 8 minutes prior to the accident, there was absolutely no debris on this beam. The second point to that is this construction project had three sites. It had a tunnel, it had the mezzanine level, it had the upper mezzanine level. Those reports pertained to the mezzanine level, which is entirely separate from where plaintiff was hurt or injured, allegedly.
So your position is that Mr. Alcantara lied when he said he saw plaintiff trip on wood or other material on the beam, right, and fall. So Mr. Alcantara actually saw him fall, record at 904 and 907. And he also disputes that they were ever directed not to walk on the beam. And that's the record at 900.
I would respond to about the obstructions on the beam, and I would direct the court to page 910 of the record, which is later in time in the testimony, where he says there was absolutely nothing on this beam.
Okay, so great cross-examination. Why should we decide that issue as a matter of law? We're not a jury.
Well, because it gets to the point now where we're clogging up the system when we have the plaintiff's pre-litigation statements to multiple treaters where this accident didn't happen. At some point, he can't indulge in fantasy and spin these tales. And that's the price.
I'm a true believer in facts and truth, but I don't think that I don't want to discuss the policy choice of whether we choose to basically throw people out of court because we disagree with their underlying claims. That's for juries to do, not for
that's not necessarily dispositive of this case, though, because then there's still the sole proximate cause issue where plaintiff, without being instructed, walked across this beam, and then there's the question of foreseeability, whether this presented a foreseeable elevation-related hazard, and this beam that he allegedly fell off.
Seems like a lot of questions of fact to me.
Yeah,
but the foreseeability.
You are way over your time, Mr. Shaw. Thank you so much.
Thank you. Have a good day. Thank you very much.
Thank you both, counsel. Sovereign LLC versus Brainchild.
Thank you, Your Honors. This is Matthew McDonald from Claire Harrison, Harvey Brandsburg for the defendants' appellants. This appeal and, in truth, plaintiff's cross appeal revolve around effectively a single issue. Should the plaintiff be permitted to expand a simple breach of a written agreement between two parties, plaintiff and Brainchild and Company, into a series of contract claims against non-parties to that contract and a half-dozen quasi-contract and tort claims? The simple answer is no.
Plaintiff or cross-appellant in this case, I mean, they previously dealt with Arrival LLC, right?
No, Your Honor. They consistently dealt with Brainchild. They only dealt with Brainchild and Company, Inc. That is the party that signed the contract and ordered all the goods from the plaintiff.
Didn't Mr. McDonald, didn't they get some payment or weren't they directed to make some of their payments and maybe receive some of their payments from KVK Tech Inc., which was a separate corporation?
No, Your Honor. That is a statement that the plaintiff's counsel makes in their brief, but it's not supported by the actual factual allegations in the complaint. What the complaint states in paragraph, it's record at, I believe, 51. The complaint states that all of the payments were made by check from Brainchild. The plaintiff attempted to supplement those allegations with an affidavit.
Well, they can do that, can't they? On a motion to dismiss?
Yes, they did. Absolutely. But my point is in that supplemental correspondence, what it showed is emails with KVK where KVK refused to send the money, saying they lacked the authority to transfer funds, and that all they could do was arrange for a check to be sent, which plaintiff alleged the check was sent by Brainchild and drawn upon a Brainchild.
In an envelope of KVK.
Yeah. So yes, Brainchild used KVK's envelope allegedly, which that using a mailing address or sharing back office staff, even if that allegation is accepted as true as it must be here, that does not establish an alter ego. Moreover, the alter ego issue fundamentally fails because even if somehow that allegation established domination and control by any defendant over Brainchild, it doesn't establish that that domination and control was used to carry out a fraud on the plaintiff, which fraud caused plaintiff's harm. And there's
and actually, could you specifically address that with respect to the individual? Because that's where I am having some issues. How does that interplay with Mr. Vapory's individual liability?
Sure. Mr. Vapory is not individually liable and is not an alter ego. Because frankly, there's just no allegation of any domination and control by him, nor any use of the corporate form to commit a fraud, right? There's no allegation.
But what about the argument that it would be difficult or maybe even impossible at this pleading stage to have those allegations, to make that allegation without some discovery?
Your Honor, that's their burden. I mean, that is the Legion of Case Law says they have to plead the requisite elements and factors to establish an alter ego relationship, and they haven't. All they've pled is that Brainchild invoices were directed to Brainchild, Brainchild made the payments, and Brainchild received the goods. They
But,
point to the
but,
use of-
but didn't they at least allege in the complaint that all of these companies or corporations operated as a single enterprise or as instrumentalities of Vapori using the brand names Brainchild, the Arrivals, and Arrivals NY for business conducted in the fashion space? So they're suggesting that he is controlling everything, and they don't have all the details yet, but they did make that allegation.
Not exactly, Your Honor. They recited the element and the factor of that issue of domination and control, but that's all they did. They just recited that element, which Metro Transportation Authority, this court's decision, says isn't enough. You can't just recite the factors that a court's supposed to consider in an alter ego analysis. You have to actually provide facts that, if true, would establish those factors, and they haven't. They've just said them. And in fact, they haven't even, the factual allegations they have don't even come close to making out the legal standard that they have to meet. To the extent they presented the facts, it's just Brainchild paid them, got the goods, and received the invoices. So there's no ground to find that any domination and control existed. But even going a step further, let's assume those allegations are correct, Your Honor, that they did make it out. The conclusory is enough. They don't connect them to any fraud on the plaintiff, nor any damage suffered by the plaintiff. To the contrary.
Well, there's over $1 million that they weren't paid. That sounds like damages to me. And they were pressured by, they say at least that plaintiff, I thought, alleged that they had no choice. They had to be more flexible. They had to keep giving defendant better and better terms because Vapori threatened to sever their business relationship. And I understood that Arrivals, which is was its major client. Now, these are all allegations, and again, as I said once before, earlier today, it seems like years ago, but it was earlier today, 30-11 motions, and we have to take what they say, and they don't know everything when they write the complaint. So I'm just wonder why I have to knock all this out, why we should knock everything out. I mean, Judge Sherwood did knock a lot of things out, but why should we knock even more than what he did?
Because, Your Honor, there's no fraud that's alleged to stem from that. They weren't confused as to who they were dealing with. They stipulated they were dealing with Brainchild and Company, Inc. And all of these issues, everything they rely upon, every fact they cite occurred and was in their possession before the written contract was signed. They can't be defrauded by information they knew and possessed. They're trying to say that somehow they were misled by things that, in fact, support the fraud having been existed. But they received the information already. They had the emails. They had those conversations. They knew the relationship amongst the corporate entities to the extent that they're propounding them as evidence of an alter ego. And they still entered the contract with Brainchild, not with Mr. Vapori. They're trying to get a guarantee from Mr. Vapori and KBK Tech and the Arrivals that they were unable to negotiate for when they actually negotiated the contract. If they wanted that, they should have bargained for it then. And if they lacked the negotiating power and the leverage to receive that guarantee, then that's just the deal they struck, and they struck a bad deal. But that's frankly not.
Thank you, Mr. McDonald.
Thank you, Your Honor.
Let me hear from Cross Appellate.
You're muted, Counselor.
I thought I had turned that on. I apologize, Your Honors. Thank you. Petek Gunay Balatsas for Respondent Cross Appellant. The alter ego issue, I mean, there's certainly been a little bit of editorializing of the underlying facts here. The critical point here is that the affairs of this individual and of his many companies were so commingled that neither our client, my client, nor even for that matter, their attorneys knew who it was that my client dealt with. Now, my client.
But you have to, Ms. Balatza, I mean, part of it is, I agree with you. You plead, overlapping board of directors. You allege commingling of funds, but what you don't allege is that it was the domination, the complete domination itself that was the fraud and caused the injury to your client. That's the problem. You don't even allege that.
Your Honor, with all due respect, fraud for the alter ego liability is not required. In fact, cases specifically say this is all dependent on the totality of circumstances. It could be even a dishonest or unjust action. And certainly the cases indicate that if the companies themselves, lateral veil piercing is certainly, if the companies are dealing two or more corporations, the affairs of those corporations have been so inextricably confused that it's impossible to determine who it was that was dealing with the plaintiff. That's certainly a basis to.
What about respect to the individual defendant? What's the interplay there?
He is the tie that binds. I mean, certainly all of these.
But what are the allegations that support a veil piercing claim? Are there, for example, allegations with respect to transfer of funds, failure to follow corporate formalities? Was domination used by him to cause an injury to your client? With respect, put aside the corporations. There's a reason why we incorporate in this country.
Right. Certainly, Your Honor. But they're conducting, he's supposed to be the person who appeared on behalf of these entities. And
so all of the allegations, I'm sorry, just answer my.
So the allegations are that he owns or controls these entities.
So that's sufficient to make him personally liable?
Certainly not, Your Honor, but there's more. So we dealt with individuals. The contact persons that we dealt with were individual representatives of Brainchild or Arrivals. And there was a little bit of confusion there because the only basis for the allegation that we dealt with, or my clients dealt with, Brainchild is defendants, the appellants say so. So we dealt with Brainchild and Arrivals. These individuals direct to companies that are all owned.
Ms. Balazza, just to be clear, Ms. Balazza, you're talking about direct contractual dealings with Arrival LLC, correct?
Right. Well, Arrivals LLC. So we got purchase orders from Arrivals. Those purchase orders direct invoices to be made payable, to be made billable to Brainchild and Co., care of KVK Tech. KVK Tech, and Mr. McDonald has touched upon this, we have on the record email correspondence that shows that they are arranging the payments. With respect to Mr. Vapori, he is represented as the strong push behind these, behind the payment terms. He's certainly the only face my clients have seen with respect to these entities, and it's very clear.
And that's sufficient. And that's sufficient to make him personally liable?
No, Your Honor, but we are certainly alleging at this point that they aren't, we're not proving our case at this point.
No, but I still haven't heard a single allegation with respect to the individual defendant. Did Mr. Vapori, for example, in his individual capacity, induce plaintiff to enter into contracts and deliver goods?
Certainly, he was the one. And by the way, there's a little bit of—
What's the allegation that supports that?
He has personally negotiated. Mr. McDonald claims that this subsequent December payment plan is the contracted issue. The underlying allegations, Mr. Vapori personally appeared on behalf of Brainchild and Arrivals, whoever they may—
Ms. Balazza, but that doesn't make him personally liable. Corporations deal through individual entities, through individuals. Contracts and payments and delivery. That's how corporations operate. It doesn't mean unless he said, I am negotiating this contract or I am ordering you to do this in my personal capacity or sign a document in his personal capacity. If he's acting in behalf of the corporation, he should not be individually liable.
Well, in any event, that's not the allegation. It's not the allegation that he has provided a personal allegation, the guarantee, but certainly he has appeared on behalf of these entities that they're now claiming don't exist. And he negotiated. And the affairs of these other companies, all of which have only him as the common thread, are so intermingled. They share office spaces. Some of them are operated from his home. They share personnel. They're intermingling, and certainly New York law provides that there is enough to sustain a corporate piercing claim here.
Thank you, counsel. Counsel, let me hear you 2 minutes in rebuttal.
Yes, Your Honor. There's a core fact that plaintiff has misrepresented throughout and keeps misrepresenting, which is the parties stipulated to this issue. The stipulation reads, it is hereby stipulated and agreed that, and after several other things, Brainchild and Company, Inc., sued herein as Brainchild Company, Inc., and doing business as Brainchild, Inc., period, Brainchild Company, Inc., Brainchild and Co., Inc., Brainchild, the Arrivals, and Arrivals New York. So everything that counsel just said was directed to one of the entities that the plaintiff stipulated is Brainchild and Company, Inc. None of them are KVK Tech, the Arrivals LLC, or Mr. Vapuri in his personal capacity. That's the fundamental failing of plaintiff's argument. They've stipulated they're not allowed to make this argument. So that is the stone upon which everything rests and upon which plaintiff fails. And then, of course, still there's still the fundamental problem that even if somehow this amounted to an alter ego claim, none of it is the reason plaintiff was not paid. There's no fraud in that corporate form that defeats plaintiff's payment. And in fact, the cases plaintiff relies upon in the alter ego context consistently deal with commingling of funds that then prevents the defendant, who's primarily liable, from making the payment. There's no such allegation here. There's no allegation that Mr. Vapuri raided Brainchild and made it unable to satisfy its debt, nor KVK Tech, nor the Arrivals LLC. That is the sort of fraud that a sham of a corporate form would allow an alter ego finding for, but it's not here. And it's just not in the face of the complaint, and therefore these claims should be dismissed.
Thank you, Mr. McDonald.
Thank you, Your Honors.
Ms. Velazquez, you get a minute rebuttal on your cross appeal?
I believe we have two, but Your Honor, I'll keep it very brief. With respect to the stipulation, we sued certain entities. It's just a stipulation. That's not part of the record. It's a stipulation to extend their time to answer. The appellants came in and said Brainchild Company will appear on behalf of all of those entities. It is not a waiver of any rights, and it's certainly, it's not a waiver. It only contains one waiver. It's a defendant's waiver to object to personal service. And certainly we did not make any substantive admissions there. And again, I would just like to point out that this is a mistaken application of alter ego liability, that a fraud is required, or that we need an allegation that assets have been stripped. Certainly there's a case, for example, from the Second Circuit, D. Klein and Son, Inc., 147, Fed Appendix 195. And certainly under these kinds of circumstances, lateral veil piercing is certainly possible in these kinds of situations. And any kind of the totality of circumstances is what controls. It's a fact-laden inquiry. Court after court has said this is not particularly unsuitable for resolution on a motion. And in fact, we have requested leave to replead because we have we asked the court to take judicial notice. We have found additional, there is a company that Mr. Vapuri owns that apparently, this is completely different company than what's been alleged here, that apparently owes certain registered trademarks for the name Arrivals. So we do not know. These are all facts within their control and entirely within their control. We have certainly put them together. They've held themselves out to be a complete single operated entity. And we find out now that none of these companies, they're not even registered DBAs. They don't even exist. And under the circumstances, New York law is clear that that would justify piercing of the corporate veil. Thank you very much.
Thank you both.
Thank you.
Yeah.
Last, Jane Doe versus Turnmill.
Good afternoon, Your Honors. Leonard Lesser for the plaintiff appellant Jane Doe. I hope you and your families are safe and healthy, and I appreciate all the time you have all spent this afternoon. I'll try to be as brief as possible. We're here as a result of a brutal rape of the young woman Jane Doe in the isolated ladies' bathroom in the basement of the premises at 119 East 27th Street. It happened on Saturday, April 11th, 2015, just before 8 p.m. The assailant was Rodney Stover, a level 3 sex offender that was living nearby the premises at the notorious Bellevue Men's Shelter with 24 other level 3 sex offenders. And that was a half a mile away, a 10-minute walk from the president.
Where was it? Where was the Bellevue Center?
400 East 30th Street. which is literally a half a mile away, 10-minute walk.
Yeah,
You can look on MapQuest.
No,
Okay?
I know the neighborhood.
Yes. The defendant in the court below characterized what happened to Jane Doe as a quote-unquote unfortunate assault. That was a gross mischaracterization. This was a brutal rape caused by the failure to maintain the premises in a safe manner. And I'll tell you why. There was actual notice of the unsafe nature of the premises. The premises operator purchased 10 security cameras.
But how is that notice, counsel? How is purchase of to the extent we can consider the cameras, how is that notice of prior criminal conduct?
Well, it's notice of the need to have the security enhanced in the basement. They purchased these 10 cameras for the very purpose of securing that basement. 10 cameras that had to be included in the basement areas, including right outside the bathroom, pursuant to the New York Police Department's best practices for establishments like this. They bought those cameras for that very purpose, Judge Singh, for the very reason that they knew that security was deficient in the basement. And then what did they do? They sat on those 10 cameras for 4 months. They started the installation.
So let's assume they hadn't purchased cameras. Could there still be liability?
Of course, because we also have the issue of the fact that they didn't have the security agents, the bouncers, which I'll get into for a second, but I want to come back to the security cameras because I have to finish this point. They held on to those cameras for 4 months. They started the installation, but the operator decided to save money and not rehire the security consultant that they had hired in August of 2014 to put in the new security devices and the interface, the software. They waited for those 4 months. What was on at the premises on the night of the rape, there's a photo of it. The NYPD took a picture of it, 2/11/13 in the record. The wiring was there. There's a missing camera. It's not there. None of the cameras are there. The NYPD comes back a few days later after the rape on April 23rd, 2015, and that's in the record page 2115. And lo and behold, the camera is there.
Can we consider that fact? Can we consider? Of course, it's remedial.
This is not a remedial measure. The fact that they buy the cameras for the very purpose of enhancing the security that they knew was deficient, deliberately wait or negligently wait to install them, and then only complete the installation a few days after the rape can't be converted into a subsequent remedial measure. Quite the opposite. It's evidence of negligence. It is not subsequent remedial. They had these cameras for 4 months before, and they didn't complete the installation. They started it. Now let's go to the bouncers. Now, as we point out into the record, the defendants first denied that they ever hired any bouncers for the premises. Upon further discovery in the case, they finally relented and admitted that they did have bouncers. They had bouncers through Elite Security. But they didn't start the bouncers on Saturday nights until 8:00 p.m. And that's notwithstanding the way they operated this premises. And it's all in the record. 2029 is the advertisements for happy hour all day, all night, every Saturday. 2029 and 2030, the advertisements for disco and DJ dance parties, no cover charge, every Saturday from 8 p.m. to 4 a.m. And at page 2031, the sign that they put out in front of the bar advertising all-day happy hour between 12 p.m. and 7 p.m. This rape happens just before 8 p.m., just before they decided to have the bouncer start. The bouncer testified and he offered an affidavit that says that once he's on duty, he checks everybody's ID, he patrols the downstairs basement areas, and he surveils the premises. They deliberately chose not to put this bouncer on duty during their all-day, every Saturday happy hour and waited until it was too late. They also testified that after the rape, they started the bouncers at 5 p.m. That, too, was not a subsequent remedial measure, Judge Singh, because I questioned the operator about that. He said the only reason they started the bouncer after the rape at 5 p.m. was not because of the rape, was because it was getting busier at the door. So that's evidence of control. That's evidence of their ability and their responsibility to have the security staff at the premises when there was enough of a crowd in the place to justify it.
So,
And
so
we
it's
know-
your position that and there are REMA cases which talk about prior criminal activity at the place or in the general vicinity of the area. Just we don't even analyze this case under that lens.
You don't have to. There's actual notice and knowledge of the deficiencies in their security, and that's the very point, Justice Singh. The ambient crime cases, that's not applicable here. We have evidence of them engaging in trying to, one, fix the negligent security devices in the basement, and two, making a deliberate decision to promote all of these activities at the bar that bring in drinking crowds, but not have their security at the bar at the time of this rape. This security guard missed this rape by 15 minutes. Had he been out there, Stover would have been asked to give his ID. He would have seen security at the door. Had they had the security guards patrolling the basement, he wouldn't have gone down there. Had they had the security cameras installed as they bought them to do 4 months before, he would have been alerted to the fact that he was being watched. He was being surveilled. This doesn't happen. Remember, he walks into this bar because he was undeterred and undetected, walks around, doesn't order anything, goes down into the basement, sneaks into the ladies' bathroom, and lays in wait for his victim, who happened to be Jane Doe. These are defects in premises security deterrence that, as a matter of law, constitute proximate cause. Maybe not the sole proximate cause, but a proximate cause. I do need to say, and I want to make this clear, that we don't even have to get into any of these arguments because they didn't make their prima facie burden. I want to be very brief on this. Their entire motion was predicated upon unsigned affidavits, which, although in their appellate brief they say, oh, we submitted the signed notarized ones to the court below, that's towards the record. What is not towards the record, however, is the judge decision where she acknowledges at record page 22 that these affidavits were not notarized. We also have Attorney Goldberg and their experts purely conclusory moving affidavits that not only cite to nothing, but misrepresent the record. They say that there was no evidence or notice of any prior assaults or crimes either at the bar or in the vicinity. That was blatantly false. Kiami, the principal of Harvard, testified that there was an assault in a girl in a bar a few blocks away from the premises a few years before the rape in another building that he owned and operated. And we also know that Lucas of Turnmill testified that there was an assault at the Turnmill that he had to call the police for, that they had to eject the perpetrator. So those conclusory affirmations of counsel and the expert were groundless. They try to fix the expert's affidavit on a reply by submitting a reply affidavit with new evidence.
Your time has run out. Thank you so much. Mr.
Uh,
Goldberg?
May it please the court. There is no proximate cause to any of the allegations that are adduced by counsel for the plaintiff. It's an unfortunate assault. The surveillance camera.
Well, Mr. Goldberg, it's much more than unfortunate. I mean, that's.
Yeah, I understand that. I'm not trying to diminish what happens.
So you know, just argue your case. Well, what about your adversary's point that that we don't have to go into prior criminal conduct? You know, the line of cases starting going back to Nayland, but rather we can look to what you did, what you knew. You needed security cameras. You bought them. You didn't install them. Your security guards could have been there earlier, et cetera, et cetera.
All right. The cameras that were in place at the time served the purpose. And the purpose of surveillance cameras, according to the witnesses, was to do surveillance and identify falls, thefts, incidents that occurred.
But what about Mr. Lesser's testimony that when the cops came and checked it out, did an investigation right after the rape, that there were wires in the walls but no cameras? So obviously you knew that you needed to have cameras there, or you were planning to have cameras there, and you had gotten pretty close but didn't get the camera up there. What good are the wires?
Right. There is no doubt that they were planning to install the cameras, and they didn't for a period of time. Let's assume, arguendo, that the cameras were there. Is it expected that somebody is looking at a monitor 24 hours a day and would see somebody walking into the ladies' room as opposed to the men's room, which is right next door to each other? It's something that is not in a burden that's imposed upon a restaurant owner or a landlord for that matter. As a matter of fact, when the plaintiff was in the ladies' room, one of the guests at the same party she attended was down there, walked in, didn't see anything amiss. The manager went in, used the ladies' room. She didn't hear anything. Another employee knocked on the door to put in paper goods.
But the manager did see the perpetrator, a creepy guy in the area, and had there been the security guard, that security guard would have at least asked for ID, no?
No, that's untrue, Your Honor. And if you look at the photos, what that was is there was a testimony by the plaintiff to the effect that when Mr. Lucas, who was not present at the time of the occurrence, but came after he was advised of it, showed up, that he allegedly said that this man was creepy and was carrying newspapers. If you look at the record on pages 221 to 224, which showed photographs, the surveillance photographs of the assailant entering, going down the stairs and leaving, you could see he's normally dressed. He's not disheveled. He's not creepy looking. I mean, there's nothing.
So Mr. Lucas told the detectives that the guy was carrying magazine stuff in his pocket and that he looked very creepy. So
that is what the allegations are by the plaintiff or her fiance at that time. Mr. Lucas says he doesn't recall it, but if somebody said he said it, he said it. But it's not true. It's based upon his observation of the surveillance.
But aren't these issues of fact? I mean, you know, I've said this a lot of times today. There's a lot of cases where there seem like a lot of issues of fact in these cases.
Judge, there can't be an issue of fact when you have the photographs and the surveillance photographs of him, and he doesn't look like that. The court can look at the photographs. It's not an issue that he was creepy and carrying newspapers. You have his surveillance photographs. As a matter of fact,
what about Mr. Goldberg? What about Mr. Lucas's knowledge? He says that he was unaware of the presence of the men's shelter, which was right there in the vicinity of
7/10 of a mile away from the place where the restaurant is. It's near Bellevue. I did a Google search. It's 7/10 of a mile away, and 7/10 of a mile is a different world in Manhattan.
Well, I hate to tell you, if this premises was at 119 East 27th and the shelter was at 400 East 30th, honestly, that's probably not 7/10 of a mile, but it's, I mean, because we all know that area and we all know how the city blocks work.
Yeah, but Judge, what is a restaurant owner to do? In other words, if there's liability, what the court will have to do is impose security guards, surveillance, everything in every restaurant or place of public accommodation in that area. We're in a low crime area. The expert that was submitted by the defendants was a former captain of that precinct. We gave FBI and police precinct, New York PD, statistics that show it's a relatively low crime area.
Counselor, was there evidence of criminal activity around the shelter?
No, the around the shelter, that I don't know. Around the restaurant, there was one occurrence that my client testified to in which there was an altercation arising out of Blue Smoke, which is a restaurant right across. There was a party that sort of came over to his place, and that was one occurrence. There was testimony of some type of assault at another restaurant. That was not of a sexual nature. We didn't get into that, so we don't know what kind of assault it was. And that's it.
Assault and altercations take place when you're serving a happy hour for all day, right?
But you have to understand what happened. The restaurant was not filled. There were two parties. There were children having dinner there. There were all types of people. It wasn't happy hour at that point. It was happy hour, but there was no music. It was a regular establishment. People go to a bar. They have 2 for 1. The fact that it's happy hour doesn't impose a significant liability. This is not a dram shop act. I mean, even if a person was there at the front door, what is he supposed to do? This man was over 21.
Thank you, Mr. Goldberg. Mr. Lesser,
Thank you, Judge.
2 minutes.
I'll be as brief as possible, but we just heard Mr. Goldberg. He's not an expert in this case, but he certainly is trying to be one. The point on the deterrence, All right, this is not a case where you have to have every restaurant having all of these devices. This is this particular place, the way they operated on Saturday nights with their all day, all night happy hour, with their DJ dance parties that started at 8 p.m. The testimony is that it was crowded. Mr. Goldberg talking about children. There were 2 parties, drinking, dining. Nallen case specifically says where there's expert testimony, and we had sufficient expert testimony here, even if you find they satisfied their prima facie burden, where the expert testimony is that the assailant would have been deterred had the security devices been in place. That's sufficient to raise triable issues of fact on proximate cause.
I haven't read Nallen, I'm afraid, in many years, but wasn't there there was notice of prior criminal activity in that case? Right?
No, it was a case in where there was they didn't have the building security in the lobby, and the assailant came in and he was undeterred. Here we had that, though. We know, Justice Singh, that they knew they needed security at this place. They hired a bouncer. They just chose to start them too late. They knew they needed the cameras. They just decided not to install them. I want to make a point on this CompStat, these statistics that Mr. Goldberg just cited to. That was first put in the reply affidavit of the expert. He talks about those, they're not admissible because they were in reply, and he only looks at one part of them, that the rapes in the 13th precinct went down from 2012 to 2014. They went from 17 rapes to 12 rapes. That's record 2226. But Mammoth, the expert, doesn't characterize this event as a rape. He characterizes it, just like Attorney Goldberg just did to you, as a quote-unquote unfortunate assault. Take a look back at those crime stats, 2226. The increase in assaults in the 13th precinct from 2012 to 2014 went from 129 to 174, a 35% increase in assaults in the 13th precinct. So even if you give Attorney Goldberg a pass on his patently deficient moving papers, allow his expert to throw in new evidence for the first time on reply, look at that. You will see they support not only that there are material issues of fact, but material issues of fact against both defendants, the operator and the owner, who in their lease maintained the obligation to repair and maintain every public portion of that property, interior and exterior, including the basement. The operator and the owner had knowledge of prior incidents. The owner had knowledge of an assault in another one of his buildings up the street, another few blocks away from the premises. The lease made clear that this operation, this premises could only be operated as a quote unquote high quality coffee and cocktail lounge. No music, no dancing. The only thing that was allowed was quiet background music. Yet they operated this as an aggressive sports bar with all day happy hour, disco dancing parties till 4 o'clock in the morning. The owner had a duty to know that the lease was being breached. The owner came to the premises, went to the basement, and also critically, Kiami, the owner of Harvard, testified that he put in security cameras in every one of Harvard's buildings. Why? Because of deterrent. He testified if somebody sees cameras, they will be deterred from doing improper things. They had security cameras all throughout this building, the Kiami Arcade building, except the owner didn't put the cameras into the basement.
Thank you, Mr. Lesser.
Thank you. Sorry for my animation.
It's an important case, Mr. Lesser. I understand the dynamic of it. Mr. Goldberg, thank you.
Thank you, Your Honor.
And this concludes virtual oral arguments of the Appellate Division First Department. Good evening.
Good evening.
Thank you very much.